My lord, may I be permitted to petition for application for intervening with regard to item number 32, my lord.
Of the original set list.
Original side.
Yes,
On
please.
3 of CBA. I will serve notice my advocate on it.
Please do. Yes.
Lord,
Yes.
last two items, my lord, items 32 and 33.
Yes.
My lord, very short matter. Why? Similar matters have been disposed of by your lordship, my lord, for the directors and my lord, other non-executive directors, my lord, setting aside the fraud and LOC. This is, my lord, another non-executive director. So it will, my lord, take perhaps very short time, my lord, 2 minutes. My lord, the same company, other directors have been exonerated.
The difficulty is that the part heard matters have been kept pending for so long. That's why we have kept those are before the assigned matters.
Yes, yes. But I am saying, my lord, the last two items, 32, if it can be taken up, my lord, in
Not right now. Not right now. Let us dispose of some matters, some of the part heard matters, then we'll come.
then I'll come
Come back after 2 weeks.
after 2
After
weeks.
2 weeks.
Happy New
Ha, simply.
Milords, if I may seek your leave to mention a matter.
Yes.
Milords, I am mentioning a contempt application which is pertaining to Jalpaiguri Circuit Bench. We want to withdraw that application. Parties have settled.
Very well.
Milord-
Give the number, it will appear as to be mentioned so that we can pass that on.
Yes, Milords, I had mentioned it last week also, if your lordship can direct the court master.
No, appellate said mentionings you have to make the mentioning at 2 p.m. when you take up the appellate said matters.
Milords, this is circuit bench, so 2 p.m. Milords.
Circuit bench 2 p.m. Mention at 2 p.m. Mention at
Please,
2 p.m.
Milords.
Right.
Milords, grateful.
Thank you. Yes. Call.
Item number 1 for judgment. Only a development document.
Accordingly, AP Com 255 of 2024, old number such and such, preferred by the claimant, Messrs. Konarak Enterprise is dismissed on contest. AP Com 229 of 2024 is allowed on contest in part, thereby granting the respondent its counterclaim on account of risk and cost principle to the tune of rupees 50,65,864. Hence, the balance amount after deducting the amount of claim of security deposit and earnest money awarded to the claimant from the counterclaim awarded to the respondent to the tune of rupees 50,65,864 comes to rupees 41,59,772.56 paise, which shall be paid by the claimant to the respondent Haldia Development Authority within February 28, 2025. GA1 is disposed of accordingly. No orders to cost charges.
Grateful, madam.
Thank you.
Item number 3.
My lord, I had mentioned the matter last week, my lord. My lord, in September, my lord had appointed one Mr. Shornindu Ghoshal as the
Oh,
learned
that.
sole
That's-
arbiter.
It should be Ghosh.
Yes, my lord.
In the order dated September 28, 2024, comma, the name of the learned arbitrator who was to be appointed was erroneously mentioned as Shornindu Ghoshal instead of Shornindu Ghosh. Full stop. Accordingly, the order dated September 18, 2024 be deemed to stand corrected to the effect that Mr. Shornindu Ghosh, senior advocate, was appointed as the sole arbitrator thereby. Full stop. Let this order be deemed to be a part of the order dated September 18, 2024.
Grateful, my lord.
10:30 target up.
Item number 5.
But I appear for the petitioner.
Yes.
My lord, the respondent contempt was supposed to file the show cause.
Yes.
And she was to be, with Mr. Majumdar's leave, she was to be present.
Virtually or physically.
She's there.
She's there.
Yes. Yes. Mr. Dotto, yes, what is your?
Yes, my lord, the lordship may kindly, my lord, have a look to the affidavit. Kindly take, my lord, paragraph, my lord, with
The copy of the affidavit has not been served upon us.
well, it was sent through email yesterday, but I am told, my lord, to on a wrong email. Mr. Srivastav had 2 email IDs. It has
Oh.
gone to a wrong email ID.
It bounced.
It did not bounce.
So what is the cause shown?
No, the explanation is, my lord, I'll be very, my lord, very candid, my lord. We are awaiting, my lord, the appeal court's order.
What is the stage of that appeal?
My lord, the delay has been condoned.
No, my lord.
I think
No, my lord. In state's appeal, there is no delay is yet to be condoned. But there is no appeal in the eyes of law.
WBIDC,
Well,
No, WBIDC, the officials of WBIDC have not been implemented as contemners in this petition.
No, the what
Let
is
me tell you,
it?
Lakshman, what has happened.
Yes.
Well, after we received the
Eight, madam.
contempt rule, it was found that the contemptor, who is the MD of WBIDC as well as Milord, the head of the department of the state. Now she has been Milord implemented as or alleged as a contemptor as the secretary of the department. But Milord, appeal was filed Milord on
She's also the MD of the WBIDC.
WBIDC.
But
Appeal
my lord, yes.
behalf of WBIDC delay condoned. After we received the rule, we felt that the
State
state
also should file.
should prefer an appeal.
That section 5 is pending.
That is after Miller, it was filed
Madam-
I think, about a week back.
So when has the WBIDC appeal been fixed?
Running in the list.
It's running in the it's in the list
Lord,
today.
could I, with the leave of the Learned Advocate General and Mr. Mujumdar, kindly have a look at Your Lordship's order of 22nd of November 2024. This plea was taken, Your Lordship considered it because it was WBIDC's appeal and not that of the state. The state was to file a
No, this MD aspect was not pointed out at that point of
No, my
time.
lord, may I just point out? May I just point out to your lordship? Am I audible? May I
Yes.
just point out to your lordship? Your lordship's order is a two-step order. We are at the first step. That is
Yes.
the release of the funds by state in favor
Yes.
of WBIDC for disbursement in turn disbursement in favor of the petitioner.
Yes.
So we are at stage one. At stage one, WBIDC officials have not been implemented as contemptors. The contempt petition is limited to stage one at this stage for the present.
So
So,
state
Malad,
is to
at-
disburse this, that
Yes,
amount.
Malad, this is why whether WBIDC has preferred appeal or WBIDC has not preferred appeal, it is the state who has to answer. Malad, the contemptor
Can even
may
Mr.
act-
Mujumdar, the same order has been challenged in both the appeals.
Right.
So, I mean, whatever is the outcome of any of these appeals will govern the fate of the entire order. So we
Malad-
have to look
Malad,
into that also because this at this stage would it be proper for the single judge to, I mean, pass
Malad,
penal
as
measures?
an officer of the court, Malad, I must say, Malad, they should take steps for immediate, Malad, hearing
Yeah,
of the appeal.
understand that, but the difficulties we also know the practical difficulties in that because I mean it's like giving a direction on the division bench to
No, I'm not on that. Malad, I'm just indicating since the
Yes.
learned advocate general is there.
Mr.
I
Atto,
would
what
just
is
request the
the
learned advocate general that the
present
state should
what
take.
is the current item number or something? Give some
You know,
detail.
it's today's it's in today's list as the last item. That is the WIDC.
Mr. Datta, I'll record an order in my order. I'll record something that you have your submission that you will have it mentioned immediately for upgradation.
Yes, Malad. That
But in fact, Milord, if the other matter is called on today, we can definitely request the
please,
Honorable
yes.
Judicial Bench to tag the other appeal also.
We'll give you 2 weeks time. I'll
Right.
give you 2 weeks time as a last chance. I'll record that it's a last chance. Otherwise, we have to whatever penal measures we'll take, we'll take.
Definitely.
It is submitted by learned Mr. Banerjee. You are appearing with Mr. Mujumdar.
Yes, Malad.
Very well. It is submitted by the learned advocate general that the appeal filed by the state against the parent order is at the stage of hearing of the condonation application. However, the appeal preferred by the WBIDC has crossed such hurdle and is due to be taken up by the concerned division bench, taking up appeals. Next para. Learned senior counsel appearing for the petitioner submits that the parent order was a two-stage direction. At the first stage, the state was to disburse an amount, and at the second, the WBIDC was to pay the same to the petitioner. As such, what is germane is the present stage of the state apostrophe appeal. Next para. The learned advocate general appearing on behalf of the alleged contemptor submits that the alleged contemptor is working in dual capacity and is also the managing director of the WBIDC. Next para. In any event, it is evident that both the appeals, although at various stages, are pending adjudication before the concerned division bench. Moreover, the outcome of either of the appeals shall govern the fate of the present contempt application as well. Full stop. Next para. Since the learned advocate general assures the court that appropriate mentioning will be done before the concerned division bench, comma, pointing out that no further time is being granted by this court, comma, either to obtain ad interim orders or to get the appeals disposed of. Full stop. Next, comma. This court is of the opinion that for the sake of propriety, comma, in order to enable the appellate court to have a say in the matter, comma, the contempt application is postponed till January 31, 2025, when it will be listed for being taken up at 10:30. Full stop. It is, comma, however, comma, made clear that in the event no order is passed by the appellate court in either of the appeals, uh, comma, there would not be left any other option for this court but to issue penal directions for non-compliance of the order of this court. Full stop. The show cause filed in the form of an affidavit by the alleged contender today be kept on record. Full stop. A copy thereof be handed over by the course of the in the course of the day to the learned advocate for the petitioner.
It's already been given. It's
Last sentence যেটা বললাম ওটা কেটে দিয়ে a copy thereof is handed over here and now to the learned advocate for the petition.
Lord,
Grateful, grateful,
one-
madam.
9th, 7th.
Very well. February 7th, 2020.
Very well, very well.
But Mr. Datta, that will be really the last chance.
Yes, yes, definitely. But I'll also not.
January 31, instead of January 31, it will be February 7th.
Very well, madam. Very well, madam.
I'll also not embarrass me.
No, next time I'll be really embarrassed. I won't be able to face Mr. Mojumdar and Mr. Banerjee. So I'll have to pass some orders.
Grateful, madam. Grateful.
Thank you. Now,
Milord, the next day, Milord, the appearance would be.
It is made clear that the alleged contender shall be virtually present on the next returnable date as well at the time of call.
I'm good.
Item number 4 is my application, my lord, for contempt. In the pursuant to the lordship last order of December 2024, my lord, we have added the
Yes.
officers of the contemptors as parties, and we have served the afresh the amended.
What was
copy
the
to all-
contempt?
My lord, the order, my lord, is lordship order under contempt is September 4, 2024, as modified on September 6. My lord,
Yes.
they were holding certain shares. They were holding certain shares of Adhunik as which we are offered to them. Now, out of the shares which were held, my lord, the contender number 1 had sold or transferred 8,000 shares out of the shares he was holding, which we have mentioned in the supplementary affidavit, which is at page 7. Is the document which is in the supplementary affidavit, the petition formed on
Yes.
December 9, 2024. At page 7 is Maheshwari Datamatics is the RTA, Registrar and Transfer Agent, who has informed that as on December 2, 2024, Munesh Hotila Thakur shareholding has gone down by 8,000 shares. So 8,000 shares has been transferred by him after your lordship's order. This is
So
the
that was
only,
in violation of the injunction order.
yes, because lordship's order was passed, then the shareholding is given 10,88,000, which has come down to 10,80,000. Of
Yes, what about- what is- yes.
Adhunik, which is now known as Incredible Industries.
What is the explanation?
But I appear for Milord, the contender number 1, Milord. I appear for the contender number 3, Milord.
But I am
Yes.
appearing for 3A, B, and C. I
Yes,
am
who
not
has
a part-
transferred? Who has transferred? Yeah, please use the microphone.
Milord,
Yeah,
the allegation is that
that you have transferred.
I have transferred, Milord. Milord, the difficulty is, Milord, that the order was communicated by way of an email, Milord.
So,
Milord, my client did not notice the email. And Milord,
did not?
notice the email, Milord.
No, that's not a
And
valid.
Milord, the other part is, Milord, the hard copy which was, Milord, sent, Milord, it was probably not received. Milord, today, Milord, I understand, Milord, I am standing in a contempt of your law.
Yes,
Valid.
yes.
Milord, the only thing, Milord, I can do is that these shares are easily available in the market, Milord. Milord, I have an instruction from my client, Milord, if the the accounts has been freezed. If the depository, Milord, opens the accounts for at least 7 days, Milord, I can buy back 8,000 shares from the market and keep it, Milord, in the account, because
Time being do that. and the depository has to be directed. Depository is not a party here.
Yes, Milord, probably Milord.
You are the
we involve
depository. So I'll
NSDL R3 is the deposit.
I'll direct you to do that, to defreeze that.
7 working days, Milord, I will buy out.
They have to defreeze exactly what? What will be the language of my order? Defreeze what?
Milord, my demat account, in pursuant to your lordship's order, Milord, has been defreezed.
For that limited purpose, it will be defreezed.
I can buy back, so that I can buy back from the market and Milord keep it. Milord, I have written instruction to that effect, Milord.
Only for this limited purpose.
Yes, for this limited purpose. You are the alleged container number?
One.
Right. Learned counsel for the petitioners places reliance on the supplementary affidavit filed in court and its annexures to argue that in deliberate violation of the order of this court, the alleged container number 1 has transferred the shares in favor of the added contemners.
No, man, he has sold all.
To third parties.
8,000 shares.
To third parties. Full stop. Next para, learned counsel appearing for the alleged container number 1 contents that the initial communication was made via email, which the alleged container number 1 overlooked by due to bona fide mistake. Full stop. Next para, be that as it may, on instruction, learned counsel for the alleged container number 1 submits that if the depository, that is alleged container number 3, defreezes the demat account of the alleged container number 1, which has been freezed pursuant to the order of this court, for such
number 2.
Yes, Milord. I am only NSDL, Milord. I have nothing
numbers
to do.
2 and 3 করে দাও, the for such limited purpose, the alleged container number 1 shall buy back the shares which have been transferred and retain the same pursuant to the order of this court. Full stop. In view of such bona fide stand having been taken by the alleged container number 1, the alleged container numbers 2 are directed to ensure that the demat account of the alleged container number 1 is defreezed for a period of 7 days from date from various defreezed till January 27, 2025 for the specific and limited purpose of the alleged contemner buying back the shares which have been transferred in the meantime. Push up next para. It is, however, made clear that apart from the above, the alleged container number 1 shall not perform any other transaction pertaining to the said demat account. Full stop. The demat account shall, after such transaction being made, made and or after
Frozen again.
January 27, 2025, whichever is earlier, freeze the demat account of the alleged container number 1 again, subject to final orders by this court. Full stop. Next para. Upon buying back the shares, the alleged container number 1 shall retain the same, which will be also subject to the outcome of the present contempt application. Full stop. The application shall be listed next on January 31, 2025 for passing further orders.
Only
your conduct, then we'll pass further.
Only one thing, after
Yes,
after the alleged contemner number 1 purchases the 8,000 shares and makes it credit in the demat account, he shall also give us the intimation.
I can't hear you, Mr. Sharma. Be a bit louder, please.
But after he buys the 8,000 shares, let him also intimate us also that he has bought and it is being
He'll
credited.
intimate the court on the next date. Let him do it.
Only one thing, Milord.
Yes.
I am for 3ABC, primarily NSDL. There
Yes.
is actually no order against me. And it is also not any allegation in the contempt petition directly against me. Milord, only the contempt notice, a copy has been forwarded to my clients. So, Milord,
Mr. Shen, for the time being, your help may be necessary otherwise
Very well.
also.
Very
To
well.
give effect to the orders. So
Very
we are
well.
not
I shall.
issuing any rule against you, obviously. There is no scope.
Very
for
well.
it.
Very well. Obliged.
Affidavit service file to be kept. Yes.
Grateful.
Let us come back on 31st. Next.
Your Lordship may just kindly record that otherwise there is no allegation against me, but I am there only to to
Mr.
give
Sen,
effect.
Mr. Sen, let us pass that order on the next date. We'll
Yes,
clarify.
obliged, obliged, my lord. Obliged. I take your lordship's leave, my lord.
Yes, Mr. Sen. Yeah,
Okay.
Mr. Sharma also, yes.
Great.
Obliged.
And for the official liquidator led by Mr. Bosin.
This is that matter.
Yes, my lord.
Order
that's
ta
the
kothay? আর বাকি ফাইলটাও দিয়ে
In item number 6, my lord, the submissions are completed, my lord.
I'll pass order right now. I've given my reasons. CA 5 of 2023 is accordingly dismissed on contest without an orders to cost. Right.
Deeply obliged.
এবার 7 দেখো 7 আর 8 7 8 একসঙ্গে দেখো those are also there. আচ্ছা আইটেম ফাইলগুলো কোথায় ফাইলটা তো দিতে হবে 6 7 দুটোই দাও দুটো তো 100 টাকা হয় না 7 আর 8 এটা 7 আইটেম 7 আর 8 আচ্ছা there was another
It's for
pending
the
application
revival and the stay
another
of the
pending
winding up.
application by the security agency also.
Not an application. I have filed an affidavit.
Affidavit.
Your lordship didn't giving the explanation.
And the official liquidator has also filed a report. And
Acha,
last
this is
report
that Mysuru
regard to
property.
the security
No, my
expense.
lord, it's Hooghly.
Hooghly আছে।
Dankuni.
Yes 6 and 7 are
One is for revival, another.
Mr. Ghosh is appearing in this matter. We'll direct you to we'll direct the official liquidator to appoint a valuer, and we'll also give you liberty to appoint a valuer. Both the valuers will jointly inspect, if necessary, the premises and give a valuation report of that of the property. Now, the costs will be borne by you, subject to final orders passed in your application, and you will file a report within the next returnable date
Valuation of this thing.
of the entire property which you want to take. The scheme,
Property
by
in
the scheme,
question.
you want the property of the company, the assets of the company, the entire thing, movable, immovable, everything. A valuation of that, as rightly pointed out by Mr. Bose on the last occasion, the valuation is required because your application is also fair enough that you want to pay the
Why
minimum
not?
that amount and whatever direct. So we'll direct you to appoint a.
May I suggest only one thing, my lord, with regard to the valuation?
We are willing to pay, my lord. At
Yes,
least
we have noted that. Yes.
The valuation and everything will be done. But the thing is this, because already the winding up order was passed in the way back in the 1990s. Now the dividends have also been declared. All the creditors and everybody, or whatever, whoever it may be, the secured workers and everybody, they have been paid. Now that the only question is for the dissolution. Now the purchaser, he has been handed over the possession. Now the purchaser has already given the money, and out of that fund only the official liquidator has made out all the expenses. Now that is why on the last occasion the report was filed, that was the final report, and where we have indicated what is the amount which is lying in the hand of the official liquidator
Purchaser,
after.
any sale deed has been executed in
No,
favor
my
of the.
Only for the execution purpose, the purchaser has come up for the only for the execution purpose.
Which is his application?
That was the CA4, but that was
That was rejected.
rejected.
That was
my
attained
lord.
finality.
Yes.
So
So
there's
now
a question of the
now
purchaser cause being espoused by you.
no. But the thing is this, that whatever the money which was lying with the official liquidator, that the sale proceeds, has been exhausted, my lord.
We are not directing to pay anything. They will bear the expenses of
Yes, they will bear the entire thing, whatever
That
the
is precisely
expenses.
what I said.
Yes, but the scheme doesn't speak of that. But they have to sit with the official liquidator. What are the expenses have been met out by the official liquidator? Even the post liquidation expenses have to be taken care of it.
Let the valuation come. There will be a joint valuation by both of you, and very well I'll also direct the official liquidator to file an affidavit disclosing whatever other expenses are required to be met for the scheme to go through,
Yes, my lord.
and give a copy to them also so that
Yes.
we can
They
deal
can
with
sit
that.
together and they can resolve the issue, my lord.
Right.
Your lordship is directing valuation only. So for the
Valuation and whatever other dues are there, they'll give an advance copy to you. They'll use an
for
affidavit.
the security expenses, security guards expenses are concerned, how the applicant who has filed the revival application, how he is liable to pay, my lord?
He is absolutely liable to pay unless we pass an order, because till we pass an order, the company court is in season of the matter and official liquidator is in possession of the same. If the scheme fails, then you don't have any right at all. You don't have a present right also.
Yes.
You have only an application for a scheme to go through, and you have given an offer. it's at the discretion of the company court to refuse that offer also. If you find that the valuation is much more, and if you can't meet it, then we can pass directions for sale again, further directions.
Yes, ma'am.
So that is always open. Learned counsel for the official liquidator points out that there are several payables which are required to be met from the corpus of the funds of the company in liquidation. First up, the official liquidator is directed to file an affidavit on the next returnable date, disclosing the particulars and sum total of the said expenses which are to be met from such funds. First up, an advance copy of the same shall be served on the applicants in CA6 of 2023 and CA7 of 2024. Pushed up next para, it will be open to the official liquidator as well as the applicants in CA6 and 7 of 2023 to sit together and have a resolution on such issue. In the meantime, pushed up next para, the official liquidator shall appoint a valuer from his panel within a week from date for the purpose of carrying out an exhaustive valuation of the assets of the company in liquidation, both movable and immovable. Full stop. It will be open to the applicants in CAN 6, in CA6 of 2023 and CA7 of 2024, also to appoint an independent valuer also within a week from date. Full stop. The official liquidator and the said applicant shall exchange the names of the official valuers so appointed. First of the valuers shall have a joint inspection of the property upon prior notice to each other, and thereafter file a joint report on the next returnable day before the court, giving the exact valuation as indicated above. First up, next para, copies thereof shall be exchanged in advance between the parties. First up, next para, the entire exercise shall be concluded by February 14, 2025, when the matter shall next be listed under the same heading. First up, the entire expenses of the above exercise shall be borne by the applicant in CA6 of 2023 on an ad hoc basis, now for the time being, subject to final orders being passed by the court.
On the last occasion, my lord,
Security agency will wait for some time, and your expenses will be included by them in there.
Lord, only one thing in regards to, my lord, item number 4, my lord, your lordship passed an order for transfer. I think one thing has been, my lord, that Contempt, my lord, buybacking the share. The item number.
What did I say?
My lord probably has, my lord, the shares. It will be said 8,000 number of shares, because once, my lord, from the demat account, the shares go.
Whatever shares have been transferred.
That, my lord, it's a public domain. So, my lord, I will buy back the same number of shares. I cannot match.
I said the shares, buy back the said shares. আগের অর্ডারটা যেটা নিলে না পরে এখানে একটা জায়গায় বলেছি shall buy back the said shares. said shares যেখানে বলেছি ওইখানটা চেঞ্জ করে হবে equivalent number of shares.
Equivalent 8,000 shares I have showed.
Buy back equivalent number of shares within bracket 8,000 bracket closed as transferred. অরিজিনাল সাইডে কিছু নেই, আবার করাবে একটু অ্যাপেল সাইডে আলাদা করে করাবে।
May it please your lordship. My lord, a contempt petition that was filed by the writ petitioner got dismissed on the ground that the learned counsel, my lord, was not keeping well. Your lordship will kindly.
On the ground that
the learned counsel was not keeping well, my lord. Your lordship has been pleased to call the matter on 3 occasions, but then he was not well, as a result of which he could not respond. The order, my lord, is there at If your
It,
lordship,
it has been filed within time.
yes, yes, my lord, there's a delay. There's a delay of
What's the delay?
my lord, 85 days.
So you have not made any separate application or made condemnation is there,
Yes,
composition.
my lord, the prayer is there. I was only praying if the main matter could be heard.
Was it an order 9 rule 4 scenario? Was the other side present when it was dismissed? No.
No, my lord, they were not.
Very well. Learned senior counsel appearing for the petitioner submits that the learned advocate conducting the matter on behalf of the petitioner was seriously ill during the relevant juncture, for which the matter could not be attended on any of the occasions when it was called on by this court. Full stop. Such ailment subsided subsequently, which is also the reason of the delay in preferring the application. Full stop. Next para. Since none appeared for the respondents as well at the time of call when the matter was dismissed for default, the principles of Order 9 Rule 4 of the Code of Civil Procedure is attracted and no notice need be served of the present application on the respondents. Accordingly, being satisfied with the sufficiency of the reasons shown, GA1 of 2025 is allowed, thereby condoning the delay in filing the application and recalling the order dated September 10, 2024, whereby CC 76 of 2024 had been dismissed for default and restoring CC 76 of 2024 to its original file and number. Full stop. Let the said application be listed before this court on January 31, 2025.
Deeply obliged. My lord, I should be very
God rest
candid
the
with your lordship. My lord, from the order dated 10th September 2024, there's no reflection with regard to the respondents
Then
not
none
appearing.
appeared.
But my lord, with regard to the
No, I've recorded. This is the third occasion when none
Yes,
appeared. Oh, a petitioner.
petitioner.
No,
No,
but-
my lord,
but-
on instructions, I say that, my lord, when the writ petition was moved, one had appeared also.
Oh, then also.
Yes.
No, the relevant date is this. If someone
Yes.
appeared, then we'd have recorded that.
I'm deeply obliged.
The application 31 as 31st as well. City table. That happened. রিকল করেছে কেন? ও আচ্ছা আচ্ছা। Anyway, ওরা নেই যখন তখন আর কি হবে? None appears for the parties at the time of call. Let them matter stand adjourn for the day.
Item
Lord,
number
11, I appear for the petitioner, my lord. This is a recalling application, but it has become now infructuous, my lord, because we have already participated in the arbitration proceedings.
So we'll record that. This was a section
Yes.
11, Mr. Banerjee?
Yes, this was a section 11 application where the
Achha.
order was passed on that day. There was a resolution. So
Oh,
before
oh, oh.
it appeared. So, my lordship, I had mentioned it. Lordship had said to file a recalling application. But
Very
in the meantime, clients have appeared before the arbitrator and has sought direction. So, my lord, nothing remains.
Very well. Thank you. Learned counsel appearing for the learned senior counsel appearing for the petitioner, in his usual fairness, points out that in view of the petitioner having participated in the arbitral proceeding pursuant to the appointment of arbitrator by virtue of the order under recall, the present application for recall has been rendered infructuous. Accordingly, GA Com 1 of 2024 is dismissed as infructuous without any order as to cost.
Grateful, my lord. Deeply obliged.
Thank you. Next.
My lord, this matter was being heard. Mr. Ranjan Bachawat was arguing the 48. My lord, today he is on his legs before the court. My lord, I'm seeking.
Sergeant, till up to which? Only 12?
Yes, my lord, only 12. The 48 applications were being
I'll
heard.
make it not today then. What is the use of passing over? You don't know when they will be answered. An adjournment is sought on behalf of you are for?
My lord, I am for the respondent number 2.
We are for the award holder, my lord.
Right. An adjournment is sought on behalf of the learned counsel for the award holder. Respondent number 2. Full stop. Accordingly, let the matter stand adjourned for the day.
Lordship, I appear on behalf of the respondent.
Respondent.
The petitioner was supposed to complete their.
We have completed our submission, my lord. Last occasion, my learned friend handed over a copy of a rejoinder. My argument was this, my lord. We have submitted with regard to, because no hearing was given by the MSME council, my lord. Because last occasion, the MSME
Is it
council,
section 34?
section 34.
They
My
were
lord,
supposed to give a reply on the rejoinder. They had mentioned.
no, rejoin now. So for people, lordship can hear the merit of the matter, then we can submit on that point, my lord.
There are two.
And Mr. Thacker is leading in this matter, no, Kishan Thacker.
So what do you propose? I mean, you want to argue, you argue. Should he adjourn it?
He has already argued the matter. Only to that aspect, my lord, he makes some submission. But he is arguing court number 37, my lord. That's why, my lord.
Then come to the point, Mr. Jan. An adjournment is sought on behalf of the petitioner. Let the matter stand adjourned for the day. Mr. Bhattacharya, come back on the next. You are Mr. Bhattacharya, right? Mr. Shayan Bhattacharya. Yes, come back on the next day.
Lordship, I appear on behalf of the respondent.
I appear for the petitioner, Your Lordship.
Senior counsel, Mr. Jishnu Shah, his mother passed away a few days ago.
Oh,
So he's not
few
here.
days ago.
Yes, Lordship.
Very well. I will adjourn for the day.
Lordship, just a kind request, if it is possible to keep it on the 31st, because on the 24th he has his rituals.
Obvious. You are for the respondent.
Yes, Lordship.
An adjournment is sought on the personal ground of learned senior counsel appearing for the respondent. Push up accordingly. Let the matter stand adjourned till January 31, 2025. 31st Jan.
I'm grateful. Lordship.
Grateful.
31st.
Great. Yes. 15 to 18.
Respondents, Lords.
Lordship, we have, I'm being led by Mr.
You are for the petitioner.
Respondents, my lord.
Both of you are for the respondents.
Yes, Lords.
So don't go so close to each other. Use the mics. The mics are far apart. Or take the mics together if you want. Say what the lady will speak. Yes. Yes. Good encouragement. Yes. What do you have to say?
Led by Mr. Ranjan Bhavjawat.
Good to know that, but for them.
Sorry.
What is your prayer? Take the mic closer to you.
Lordship, it was there.
Speak out, ma'am. What is your prayer?
Lordship, it was the petitioner's application challenging the award.
So you want to move the application now?
No, sir. Your Lordship, petitioners would move the application. They would move 530 AP 530.
5:30?
Oh.
Anyway, none appears for the petitioner at the time of call. All the respondents are represented through counsel. Full stop. Let the matter stand adjourned for the day. Give your names, please.
Yes.
Both of you. Only your names.
Yes.
Only two of you. Yes. Number 19. 19, yes. None appears for the petitioner at the time of call, although the respondent is represented through counsel. Stop. Let the matter stand adjourned for the day. Number 20. Number 21. None appears for the parties at the time of call. Adjourned for the day. 2021 এটা তোমাকে নামতে হবে না মনে হচ্ছে জিজ্ঞেস
Number 22. My lord, kind leave, my lord. And
Leave to do
item
what?
number 12, my lord. My lord, it has gone down as award holder and respondent number 2, but only
Stroke respondent number 2. Award holder stroke respondent number 2.
My lord, we haven't asked for an adjournment. They had. They are the award debtor stroke respondent number 2.
Item number 12.
Yes, ma'am.
12 এ award holder আছে, হোল্ডারটা ডেটার হয়ে যায়। Item 12 দেখো, হোল্ডারটা শুধু ডেটার করে দাও, বাকি সব যা আছে। This is item number 22 who is appearing. None appears for the parties, adjourned for the day. Item number 23. Same. Wait.
23, my lord. I am appearing for the petitioner. This is my section 11 application. Milord, Lordship had directed affidavits.
There's a resolution not to appear before any court or my court today. None is
Milord.
appearing. None is appearing today.
No
Why?
one would take that resolution, Milord.
So then you have to move the matter.
Milord,
I have to have some work for the morning.
Milord, affidavit in reply.
Don't go back. Don't recede. Take your seats. You two are receding. Yes, take your seats. Next turn is yours.
Milord, there
Yes.
are around 10, 11 respondents who have over the last couple of months given us their affidavit in
You
opposition.
did not appear on the last occasion. That's why.
Yes, Milord. Milord, the affidavit in replies we have
This
prepared
application
them.
is under which provision?
Section 11.
The section will remove it.
Milord, we had moved it. The pleadings are yet to be completed, Milord. The affidavit in replies we are yet to file. The 3 sets of affidavits in opposition that have been filed, we have prepared the replies, Milord. If your Lordship keeps it the next day, we'll file all 3 together, Milord.
All 3 means?
By respondent number 2, respondent numbers 3
Yes,
to
yes,
9.
you
respondent
file
number
all
10.
your replies.
Replies together.
Learned counsel for the petitioner seeks time to file replies to all the oppositions. So accordingly, the petitioner is directed to file the affidavits in reply on the next returnable date. The matter shall next be listed on January 31, 2025 for passing orders.
Grateful, Milord.
For passing further orders.
Grateful.
31st. Next.
Number 24.
So it's not this matter.
It's been passed over, Milord. I believe, Milord, passed over for the day, Milord.
Yes.
50 to 80.
Forget. So none appears for the parties, adjourn for the day.
Item number 25.
Same.
Item number 26.
Which one? Not 26. 26 is appearing. 26-1, 26-2.
Sir,
Yes.
Lordship, I appear in item number 26. I am led by Mr. Vishnu Bhattacharya in this matter.
Start the matter.
Lordship,
If you start the matter, I won't dismiss it for default. If you don't start the matter, I'll dismiss for default.
Lordship, just 2 minutes. My brief is on the way, Lordship.
Start, you must know the facts of the matter. Just start the matter.
I'm not in this.
What does the matter relate to?
It relates to a dispute which has taken place in Universe Society.
This is a challenge under Section 34 or what?
Lordship, it's under Apartment Ownership Act.
You have challenged any order or sought appointment of an arbitrator or what?
Lordship, we have challenged an order in this matter.
Anyway, and an adjournment is sought on behalf of the petitioner.
Lordship, just kindly grant me a short passover in this matter. Very short passover.
আচ্ছা বেরো কিছু রেকর্ড করতে হবে না Passover.
Very short. Grateful, Lordship.
Passover.
My lord, I'm appearing in item number 26, my lord.
We have passed it over.
Lordship.
My lord, I'm
Next matter, please.
Your Lordship, Mr. Umran is appearing for respondent bank. He has some difficult. Lordship.
He has not come.
After 1/4.
He has not come to court. Yes.
Not to the order.
After? After 50, after?
Or kindly keep it after a fortnight. Lordship.
For the respondent. None appears for the petitioner. An adjournment is sought on behalf of the respondent for a fortnight. Accordingly, let the matter stand over till January 31, 2025.
Number 28.
You're even drop the petition. I'm praying for an accommodation with it. And
on the prayer of the petitioner, the matter is adjourned for the day.
Grateful.
Item number 29.
Lordship, I pay for the respondent bank. I'm praying for extension of time for filing my affidavit in opposition, Lordship.
1 week.
2 weeks, Lordship.
None appears for the petitioner. Learned counsel for the respondent bank seeks an extension of the time for filing affidavit in opposition. Accordingly, the time for filing affidavit in opposition is extended for a fortnight from date. Reply, if any, shall be filed within a week thereafter. The matter shall be listed next on February 14, 2025 under the same heading.
I'm grateful, Lordship.
Special assigned.
Specially assigned matter, item number 30.
This was being mentioned in the morning on the ground of urgency. Probably this. No, sorry, not this.
Next one, the next one.
You're there. 30 years, what?
Praying for a not, briefs are not.
You're for the petitioner. On the prayer of the petitioner, the matter is adjourned for the day. ঠিক আছে ওটা মুখ ভয়ার্থ মুখ করার কিছু নেই on the prayer of the petitioner none appears for the parties, let the matter stand adjourned for the day.
My lord.
32.
Filed an intervening application that may be
It
taxed.
was mentioned by Ms. Banerjee in the morning.
And I am led by Mr. Anirban Mitra, sir.
Mr. Anirban Mitra. So who is for the petitioner?
Yes. I do not know.
What is the matter about? It's a writ petition, regular writ petition. You are for the CBI.
CBI.
CBI is a respondent, must be.
Wants to be added respondent. That is why I have filed.
What is the matter about? Just tell me
Your
first.
Lordship, may I brief?
Yes,
Your Lordship,
yes.
this is a matter wherein Your Lordship in a similar matter had quashed the lookout notice as it was issued by the SBI. Now that the Bombay High Court judgment has been modified by the Honorable Supreme Court, directing that the High Court would issue permission to travel abroad and it would not be quashed completely. So in light of that, it would have to be argued once again.
The Bombay High
Both
Court.
the connected matters 32 and 33.
You are for whom, Ms.
I am appearing for Union of India in 33, Your Lordship. And in this particular matter, CBI has already lodged an FIR and there is a document pertaining to that.
So this is the affidavit of the CBI?
No, CBI wants to be added as a party, Your Lordship, because the petitioner have chosen diligently not to add CBI as a party, despite knowing the fact that the proceedings are pending before with
Has the CBI filed an application for that?
Yes.
It is not appearing in the list. Then a copy of this application should be served on the all the other parties. What is this?
Application, main application.
No, file it in the department.
All right.
File it in the department. We'll have it enlisted.
Yes.
The CBI seeks to intervene in the matter and to file an application for impleadment. Full stop. Next para. Such leave is granted to the CBI. Full stop. The learned advocate on record having instruction to appear for the CBI is requested to furnish the particulars of the application after having it filed in the department to the officer of this court during the course of the day. Full stop. Let such application be listed.
May I intervene, Your Lordship?
Let such yes.
My apology, Your Lordship, because in for Union of India, all departments need to e-file. It could not be done within the course of day, Your Lordship. Anyways, it will be Can 1, but however, e-filing is mandatory, so it would take by Tuesday.
তাহলে during the course of the day যেটা বললাম না এই এটা কেটে দিন বাবু কেটে দিন আমি নতুন করে বলে দিচ্ছি the CBI bracket Central Bureau of Investigation bracket close
BSFB branch, Bank Fraud Security Branch. BSFB, Bank Fraud Security
bracket the CBI within bracket Central Bureau of Investigation comma BSFC
FB
BSFB
Kolkata branch
comma Kolkata branch seeks to be impleaded as a party to the present application and to file an application to that effect. Full stop. Accordingly, leave is granted to the said proposed intervener to file its application for impleadment by January 21, 2025, and to furnish the particulars thereof to the officer of this court. Full stop. Next para. The said application, comma, as and when filed, comma, shall be listed along with the main writ petition on January 31, 2025. Full stop. An advance copy of the said application shall be served on all the parties by January 22, 2025. Full stop. This will appear on 31st. The main matter along with this order was passed in 32 only. 467. We'll call on 33 next.
Number 33.
Yes, 33. What do you have to say? Similar prayer.
Similar matter.
Same similar order.
We do not have.
Instruction to want to file the CBI as a party. Only one in respect of 467.
But almost analogous matter, my lord.
You also have CBI. I mean, both of you have CBI. So WPO, you don't have any instruction to appear in.
WPO 467 of 2024.
No, 511 has been called on.
No instruction.
511 who is for the petitioner. Same petitioner. 33 item 33 একটা order record হবে none appears for the.
My lord, we have instruction to appear in the matter of item 33 also, but we have not filed in that matter intervening application. 32 we
You
have
don't file your instruction is of no avail.
only to file for WPO 467 of 2024, item number 32.
We are now taking up WPO 511. Whatever may be your instruction, if you don't have any interpreted application, then we can't hear you.
All right, my lord. I am praying for liberty to file intervening application.
So that's what I said. The similar, the 33 the same order, Pastor.
All right.
Exactly same order.
All right, my lord.
Do it by Tuesday and give
Much
copy to them. Thank you.
32, 33.
কিন্তু কি অ্যাপিয়ার করছিল অ্যাপিয়ার করছিল Peace.
My lord, I am appearing for the petitioner, my lord. We had completed our submissions, my lord. If you remember, my lord, this is that stock exchange matter which Mr. S.N. Mukherjee had argued.
Yes, sir.
And respondent had to start. In fact, they were continuing with their arguments, my lord. So,
who is for the respondent? You are for the respondent.
Senior Counsel Mr. Anirban Ray for CSE. Mr. Anirban Ray, along with
yes,
Mr.
CSE
was appearing, my lord. They had argued the matter for quite some time. So,
yes, right. So, very well, I'll adjourn the matter for a week and I'll request both the parties to come prepared with your written notes of arguments also on the next day.
My lord, we'll do that. My lord, the only one request, my lord, this has come up after
long time,
my lord. If it could be given some preference, my lord, so that it could be
my lord.
Heard,
no
my
preference
lord.
because on 29th November, nothing for the parties.
My lord.
Yes, Mr. Mitra.
My lord, your lordship will recall this matter. My lord, preference is a wrong phrase, perhaps. But even today, because Mr. Rai was arguing before your lordship.
Yes.
My lord,
it will appear as it is. Yes, it will appear as it is appearing.
But I don't know if Mr. Rai is appearing today or his junior is appearing.
No, nobody is there on their behalf.
Lord, that is the.
We'll adjourn for the day. What can be done?
Very well, my lord. The only thing is we are slightly anxious because we are facing a per day penalty and.
True, but still it did not appear on 29th of November as the order says.
Lord, that day we must have missed, my lord. We must have.
Anyway, you have finished your arguments. You are saying that so.
Yes, my lord. It was really for Mr. Rai. My lord, let it appear in the list. My lord, if it could get.
No precedence.
I know, my lord. I know your lordship's practice. My lord, it's a
precedence,
wrong word.
No precedence, no preference, no upgradation, whatever way you couch it.
I'm not even praying for that. My lord, we know your lordships will get a chance.
I don't want to add another parted matter without hearing the previous parted matters first, actually. So let it appear as it is.
My lord,
we'll record that your submission, your anxiety will record and we'll adjourn it all the same.
Yes, my lord, and kindly let it be in the list as it is, my lord, and
has to be. None appears for the respondent stock exchange, which was advancing its arguments on the last occasion. Full stop. Learned counsel for the petitioners expresses anxiety at the delay, in view of the urgency in the matter. Full stop. Next para. Be that as it may, since it was the Calcutta Stock Exchange which was advancing its arguments on the last occasion, an opportunity ought to be given to them to conclude their submissions. Full stop. Hence, let the matter stand adjourned till January 24, 2025. Full stop. Next para. It is, however, made clear that the arguing respondents should be present on the next returnable date.
I'm so grateful.
Should I recall the order? You will make your arguments. No, we can You are ready in the matter?
On a division bench,
Then the order remains. We will not record your submission.
what is the order?
None appears. So whatever necessary consequences has taken place. Consequence will be in the dark till you see the uploaded order. No, they won't tell you. Why should they tell you? wait for the order to be uploaded.
Then, my lord, let me do the.
At best, what can the court do? Close your arguments.
Yes, my
That's
lord.
the worst thing that can happen
That
to
is
you.
why, my lord.
So be in the dark. Look up the. No, I passed my order.
Then can pass this over, my lord, let my brief come. My lord.
No. Your brief is your headache. Why should the court be bothered with counsel's brief?
It's my request, my lord. I'm not. My lord, why should I-
Refused. They have passed my order. আর কোনো অর্ডার নেই তো ঠিক আছে তাহলে ওদের ডেকে না একবার কফিটা খেয়েছি তবে একটু বাড়ায় অ্যানাউন্স করে দিতে হবে অ্যাপিলেট সাইড নেবে মিস্টার রায় have adjourned it till the next day on the recording that you are not there. তো করবো সেবির কথা বলে সেবিতে অ্যাপিয়ার করছে স্টক এক্সচেঞ্জে অনির্বাণ রায়ের নাম হবে না কারণ এই অর্ডারটা আমি রেকর্ড করেছি যে on this occasion because you did not appear when the matter.
But I ran to save the matter because when I don't
Everybody else was here. Sebi was here. Petitioner was there.
only my
Only you.
my side no one was there. Sorry.
So you lies and take up the appellate side matters. Original side সব হয়ে গেছে.
My lord, if I may,
Yes.
item 21.
Yes.
I rushed, my lord, but I was just a second too late. If my lord may kindly,
What have I done?
No,
Not today.
Very well, my lord.
But kindly do what?
My lord, may kindly, my lord, fix it for the next week. My lord, I have,
No
my lord,
fixation.
my execution is stuck. The award has been stayed.
Courts cannot have a fixation. On anything.
Very well. Right.
Hateful. Thank you. Call. It at 2 p.m. No, 2 p.m. না 5টা over till 2 p.m. এ রাখবেন।
Number 2.
Passed over.
Item number 3.
Same, passed over.
Item number 4.
Passed over.
Item number 5.
Passed over.
Item number 6.
Same.
Item number 7.
Passed over.
Item number 8.
8 milligram for the petition.
Any caveat?
Well, caveat is there. We have served copies.
They're taking up out of
Well,
time.
just now we have been informed from the
public address.
public address system.
We'll pass over for the time being. Pass over.
I will inform the other side.
Please do that. If you
I'll-
can bring him, I'll take up in the middle. I'm passing it over for the.
I'll try.
Item number 9.
By default, pass over होते থাকবে. Pass.
Item number 10. Item number 11. Item number 12. Item number 13. Item number 14. Item number 15.
একটু আস্তে আস্তে করো।
Item number 16.
Pass over.
Item number 17.
My lord, I am for the petitioner, my lord. There is a caveat I have served, my lord. 24th is the date fixed before the executive court.
Give an intimation to the other side. I'm just passing over. That's why I'm not making not to.
Shall I come back at 2, my lord?
If you can bring your other side before that, I'll take up.
Okay.
I'm waiting for matters where both sides are.
Deeply obliged.
Pass over. Pass over. Pass over. Pass over. Same.
Item number 22.
Pass over.
Item number 26. Item number 24. Item number 25. Item number 26. Item number 27. Item number 28. Item number 29.
Pass over.
Item number 30.
Pass.
Item number 31.
Pass over.
Item number 32. Item number 33. Item number 34. Item number 35. Item number 36. Item number 37. Item number 38. Item number 39. Item number 40. Item number 41. Item number 42. Item number 43. Item number 44. Item number 45. Item number 46. Item number 47. Item number 48. Item number 49. Item number 50. Item number 51. Item number 52. Item number 53. Item number 54. Item number 55. Item number 56. Item number 57. Item number 58. Item number 59. Item number 60. Item number 61. Item number 62. Item number 63. Item number 64. Item number 65. Item number 63. Item number 67. Item number 68. Item number 69. Item number 70. Item number 71. Item number 22. Item number 73. Item number 74. Item number 75.
You're appearing in which matter?
Lordship, it's 55.
What's there's a caveat. You're ready in the matter.
Lordship, Mr. Karthik Bhattacharya is appearing. He's just in on his
Let him
place.
come. Yes. We are passing over matters. Yes.
Item number 76. Item number 77. Item number 78. Item number 79. Item number 80. Item number 81. Item number 82.
We are passing over if both sides are there, or if there is no caveat, we'll take up. Let us call.
Item number 83. Item number 84. Item number 85. Item number 86. Item number 87. Item number 88. Item number 99. Item number 90. Item number 91. Item number 92. Item number 93. Item number 94. Item number 95. Item number 96. Item number 97. Item number 98, 99. Item number 100. Item number 101. Item number 102.
Any matter in which either there is no in civil divisional matters, either there is no caveat or both sides are present.
My lord, item number 41, I'm for the opposite party. There is no caveat though. Lordship, we seeking for the
55, Lord. 50 there is no caveat. 55 there is no caveat. Opposite party I cannot take up. I'll continue after recess.
Item number 20 is only for the speedy disposal without any adjournment.
Item 20.
20.
So
Nothing
আপনি একটু নোট করতে থাকুন item 20, item 40, item 20, item 50, 55, and any other matter where there is no caveat. Mr. Ghosh, which
But
matter?
item 98, 99, there is an application for restoration, and the main matter, my lord, FMA is also assigned. Both the matters are assigned.
Mr. Ghosh, any other side is there or copy service?
Not now.
This for the first time, appearing for the first time.
Is it pending in the list for a?
No, not that. I mean, no direction for.
What I am praying, my lord, let the matter be restored and the main matter be placed in the list.
Well,
It's
Mr.
the
Ghosh,
assigned matter.
No, restoration for restoration, you have to give a notice to the other side.
That has been given. My learned junior is not here.
Mr. Ghosh, since I am not scheduled to take up before recess these matters because the original list has fallen.
As soon as I heard the matter.
No, we know. I know obviously I know the plight of the
I
advocate.
was trying to take
Sir,
chance.
what I am doing before recess, I am taking up only those matters like civil division or civil matters where either there is no caveat or both sides are present. If your other side is not present, then I'll not take up before recess. I'll take up after recess as usual. So for the time being, let me take if your learned junior can inform the other side and you can bring him.
I'm trying to.
If you can do that, I'll take up 3 matters which have been there are no caveats. I'll take up those matters in the meantime, and please ask your junior to inform. If you can bring before these matters are over, I'll take up your matter. Or otherwise, I'll take up after 2 as usual. So first 20 call.
My lord, it's only prayer for expeditious hearing.
Wait. Let the file come. You have to understand the plight of our officers first. 20, 50 আর 55 টা বার করুন ফাইল। 20 টা আগে আমাকে দেবেন।
দেখুন item
20 টা পেলে আমাকে দিয়ে দিন ততক্ষণ।
3046
আর বোর্ডে 20 টা দেখিয়ে দিন। What is this early hearing of what? The suit itself?
Yes, my lord.
You are the plaintiff.
I am for the plaintiff. I already advance copy has been served to the opposite parties also.
File that. What is the suit for?
My lord, suit for getting partition of the property.
What is the stage of the suit?
We prayed for the discovery of the documents. Since then the matter is kept pending.
When was it filed? 2018?
Huh? 2018, my lord.
18?
18.
Any application is pending?
Oh, my lord, order 11 rule 14.
That application is pending.
Pending.
So we'll direct the application to be disposed of within 4 weeks from communication, and the suit to be decided within 1 year after.
Grateful lordship.
Affidavit of service filed today be kept on record. Full stop. In view of the innocuous nature of the prayer made, comma, further service of notice is not directed, comma, although the opposite parties are not represented. Full stop. Next para, learned counsel for the petitioners submits that the suit for partition filed by the petitioners is pending since the year 2018. Full stop. Next para. An application under Order 11, Rule 14 of the Code of Civil Procedure is also pending in connection with the same. Full stop. Learned counsel seeks an expeditious hearing of the suit as well as the connected application. Full stop. Next para. Accordingly, CO 3046 of 2024 is disposed of by requesting the learned trial judge, that is the learned civil judge, senior division at Chandannagar, district Hooghly, to dispose of the pending application under Order 11, Rule 14 of the Code of Civil Procedure and or any other application, comma, if pending in connection with the suit, comma, within 4 weeks from the date of communication of this order to the said court, full stop. It is expected that the learned trial judge shall dispose of the suit itself within 1 year after disposal of the pending applications. Full stop. The parties as well as the court concerned shall act on the basis of the server copy of this order for the purpose of implementation without insisting upon prior production of a certified copy. No order is to cost. Thank you. 50 টা টাইপ।
In this matter, I am appealing for the preempter.
Section 8.
Yes, section. I filed this application and before the civil judge junior division, civil judge junior division allowed my application. Against that, the PMT has preferred an misappeal before the additional district judge.
Appeal was allowed.
Appeal was set aside, the judgment of the set aside and appeal allowed.
On what ground was preemption granted?
Preemption granted, my lord, I am the co-sharer. I am the deed has been registered, my lord. Kindly see observation made by the
appellate.
That is the judgment. Both courts' judgment, my lord. I am.
So on the ground of co-sharership.
Yeah, on the ground of co-share.
Why was it reversed?
Yes, reversed.
Why reversed? On what ground?
Ground, my lord. This is not the purchase and the ROR. Already my name has been entered in the ROR. On the basis of that, they purchased the subsequent purchaser, and this I made an application before the civil judge junior division, as per the section 8 of the Land Reforms Act, my lord.
Yes.
And got the decree. On the basis of that.
Why did the appeal court reverse it?
Appeal court reverse, my lord. Kindly see. Appeal court judgment, it starts from
short deposit.
Yes. It starts from page 30. Page 30, my lord, operative part, decisions with reasons, my lord, kindly say page 33. Point number, that is there are 4 points. Opposite party produce the following documents, that is the issue frame. And after that issue has been framed by the learned civil judge junior division. On the basis of that, point for consideration whether the case filed the petitioner is maintainable in its present form and prayed, whether the nature of
which
the
page are you reading?
Case of the property.
Which page?
My page is 32. Is
32.
Is preemptable whether the petitioner.
Yes.
For consideration, my lord, whether the petitioner is entitled to get the order of the preemption, whether the relief or reliefs, if any, is the petitioner entitled to. That is the 4 point has discussed and the has been decided. Several decisions, my lord. An ordering part, my lord, this is the page 36.
What objection did they take?
Objection, my lord. My lord, kindly see. And this case, my lord, on the point of that, this case is pending before the Honorable Supreme Court, my lord. This is not had been decided
on what
whether the preemption, my lord, that is the co-sharers in respect of the co-sharers, not subsequent purchasers. Where the co-sharers, my lord. That is also pending before the.
What point is pending before the Supreme Court?
Whether the preemption is applicable in favor of the co-sharers property. In case of rural or semi-rural or urban, whatever it may be, my lord, that is this case.
Co-sharer is one of the grounds in section 8.
Co-sharer is the ground, but that is the after purchasing the plot, my lord, the renumbered, my lord, in the rural area is another number, and this bata, that is the, and in the semi-rural or urban area, my lord, that is a sole, my lord, the duck number, my lord, plot number, my lord.
Yes.
Whether this applicable. This point is applicable, whether the preemption is applicable or not, my lord. This point is pending before the Honorable Supreme Court. And this has been decided by the Supreme Court.
No, yours is a semi-rural area?
No, I am the, my lord, the rural area. I am the rural area, my lord. This is the.
So you say that issue before
the Supreme Court.
That issue before the Supreme Court is not germane in your case, you are saying?
No, my lord. I do not know whether this point is consideration or not, my lord. I do not know, but in several
No,
cases,
the
my lord,
point
this
was
pending
taken,
before this
a
pending.
point was taken that you have not deposited the entire amount.
Yes, that is in view of the judgment of the passed by this court. That is the 10% amount, and rest amount when the decree was done. That is the rest amount has been deposited to that party. That point is scuttled by the court.
So how did the appeal court deal with this? Let us see the appeal court
Yes,
judgment.
appeal courts, my lord, kindly see order. Decision with reasons, my lord, kindly see.
The impugned
It
judgment.
starts from my lord. Yes.
Please refer to the internal pages. I'll
Internal pages, my lord, the 30. See.
no internal page.
Decisions with reasons, my lord. I am reading.
Internal page of the appellate court judgment.
Appeal courts, my lord, 30th. Have you also got it, my lord?
No, no.
That is the my lord decision
Internal
with reasons. Certified copy I have annexed. That's why, my lord.
Certified copy has internal pages at the bottom. Please
For
refer
my
to
lord,
that.
decision with reasons.
Yes.
On point number 1 to 4. Have you also got it, my lord?
Got it. Got it.
I'm ready.
Yes, please read it.
The aforesaid point are taken up together for the sake of brevity and convenience of the decisions. The learned advocate appearing for the petitioner argued that the petitioner is not entitled to co-sharer of the case property and opposite party is the stranger purchaser. The nature of the case property is dollar, which is preemptable under Section 8 of the West Bengal Land Reforms Act 1955. On the other hand, learned advocate of the opposite party argued that the petitioner is not the non-notified co-sharer of the case property. The OP is not the stranger purchaser, and he is.
You have filed the preemption application within a year from the date of transfer.
Within the year of transfer, from the date of knowledge, my lord. Not my lord, the date of from the date of knowledge. That point has already decided by the trial court, my lord.
But that was reopened.
Junior division has already
that was
considered.
reopened by the appellate court.
Yes, reopen the appeal court, my lord. The case property to the extent of 5 decimal over its RS plot, case plot number 2573, and his name has been recorded in the ROR, and he has.
Last position is that you have to file within 1 year from the date of knowledge, or
from the date of knowledge.
You have any judgment to substantiate that?
Well, that has been considered by the trial court, my lord, also.
How did the appellate court consider it? Yes.
That point has taken by the opposite party, preemptive. My lord, I am page, my lord, 30. Trial court's judgment.
So forget the trial court. How the appeal court dealt with it? Because you were challenging the appeal court's order.
Appeal court. Well, let the service may be effective.
No, not that. We have to be satisfied that
yes.
No, the point on which it was reversed is not limitation. Appellate court says that although the case was filed within time, right had not yet triggered because you have not deposited the entire consideration amount. So satisfy me that what is the last law on the position?
Last, my lord, this is the
Barashat Eye Hospital was probably considered in later decisions.
Yes, later.
So cite those judgments.
Those judgments, my lord, kindly pointed out by the learned appeal court. Have pointed out the Nurul Islam case, my lord, Kamala Rani Rai case.
No, but unless you deposit the entire, you can deposit it later. But unless you deposit it, whether the limitation, the preemption can be granted by the court. That is the question. Without deposit, the preemption cannot be granted. Before the final order of preemption is passed, you have to deposit that amount.
Yes, within 1 month. Against that, my lord, they preferred an appeal. That's why I could not deposit this. Yes, my lord. Within 1 month, they have deposited in the trial courts, my lord. That is the, kindly see the page 37, trial court's judgment, my lord. The opposite party is entitled to withdraw the consideration amount calculated in respect of the PM deposited land along with the statutory interest at the rate of 10%, which amounts to rupees 34,300.
Oh, it is already lying in deposit.
Out of which, my lord, page 37.
Yes, yes, it is already lying in deposit. That means
Deposit,
you have
yes,
deposited.
already lying. And this withdraw and the balance amount should be deposited. Until unless the calculation the amount, how can I deposit the accurate amount or actual amount, my lord?
You did not deposit the entire consideration amount?
No, I am not. I am 10% of the valued amount, my lord. That is the rest amount, my lord, out of which 11,459 is already lying. Deposit. The petitioner is directed to deposit remaining amount 22,916 within the 1 month from the passing of this order.
You deposited 10%.
10%.
Please show me the. Have you got a copy of the Act? Land Reforms Act.
I could not follow on a sudden this bench is.
Land Reforms Act, West Bengal Land Reforms. এখান থেকে দিতে হবে Land Reforms Act. হ্যাঁ বইটা আর কি
1955.
West Bengal Land Reforms Act. এখানটা দেখ। পেয়েছি ছেড়ে দিন। But section 8(1) says you have to deposit consideration money together with the further 10%. So how do you overcome this? Section 8 says you have to deposit the entire consideration money together with further sum of 10%.
Consideration amount, my lord, I have deposited. Consideration at that point, present market value and 10%, that is the enhance the price of this property. So far, I think, my lord, that's why, my lord. As per the deed value, my lord, I have annexed the deed.
No, the appeal court says full deposit of consideration has to be given. If there is any contrary judgment, show me that.
And
all the judgments were considered, and the appeal court says no, you have to deposit the full amount.
But give me the time on this court, my lord. Don't know. The matter may be fixed on 29th, my lord.
Let us just see.
I am not available due to my relatives.
Let me see the order. Please take your seat. I'll just go through the order.
Yes, my lord.
You had deposited the consideration amount according to you, which is correct.
Yes.
What had you deposited? Only 10% of the entire amount, or
deed value, my lord, kindly see I have annexed this value deed, my lord, page 17 starts from, and the page 25.
Page 25.
Market value and the market value after this, my lord, the deed amount.
What was the consideration mentioned in the deed?
No, in the deed had not mentioned, my lord, but in the
deed, no consideration
Government
was
of
mentioned.
West Bengal's chart, my lord, 25 page.
Page 25
That
yes.
is, it reveals the market price. In the rural area, my lord, the market
Market
below
value has been
price,
assessed at 31,250.
31,000.
How much did you deposit?
As per the market price.
Huh? You did not deposit that entire amount?
No, my lord. Actual amount, my lord, they have purchased the land. That's why this amount I have deposited. So far, my knowledge is concerned.
No. What amount did you deposit?
My lord, I deposited, my lord, the 11,000 something, my lord. But actual,
Why 11,000? How did you arrive at that calculation?
well, that is there as per the deed. I came to
That is what I am
learn from the, my lord, the
show us from the
neighbors
deed.
of the locality.
The deed is a transfer deed.
Yes.
Sale deed. In the deed, no consideration was mentioned.
No consideration money. That is the not mentioned in the above. Well, kindly see, it starts from page 17. No
The deed
consideration. Yes,
consideration was
Dikrito mullo or whatever mean mullo, that is not mentioned in the deed, my lord. That was not mentioned. Only 5 decimal land, my lord.
No. Sarbochcho Mulya, it's mentioned at page 20. 31,250. Page 250, page 20, it's mentioned. The value is 31,250. So you have given a short deposit. The appeal court was justified. Before the preemption order is passed, you have to deposit the entire amount.
31,250.
31,250, but you deposited only a meager amount.
11,000 something.
So why should there be an interference? The appeal court rightly dismiss your allowed the appeal. As per the current position, at least before the preemption order is passed, you have to put in the entire amount.
Definitely. But against that, this appeal, I could not file this amount, rest amount, my lord. This within 1 month, they prepared an appeal. Trial court has directed me within 1 month, you have deposited that rest amount along with interest.
The present revision arises out of a judgment of reversal passed by the appellate court, thereby setting aside an order of preemption passed in favor of the petitioner under Section 8 of the West Bengal Land Reforms Act 1955. Full stop. Learned counsel for the petitioner raises a question as to whether the learned appellate judge was justified in setting aside the preemption order on the ground of short deposit having been made by the petitioner. Full stop. Next para. The question which thus falls for consideration is whether on an interplay between sections 8 and 9 of the West Bengal Land Reforms Act, the consideration amount could have been directed to be deposited, the actual consideration amount could have been directed to be deposited later, after ascertainment of the same. Pushed up section 9 within bracket 1 of the act provides that on the deposit mentioned in subsection 1 of section 8 being made, that is the consideration amount along with 10%, the munsif shall give notice to the application, notice of the application to the transferee, and on such notice being served, the transferee or any person interested may appear within the time specified in the notice and prove the consideration money paid for the transfer and other sums, if any, properly paid by him in respect of the lands, including any sum paid for annulling encumbrances created prior to the day of transfer, and rent or revenue, cesses, CESSES, or taxes for any period. Full stop. The Munsif may, comma, according to the said provision, comma, after such inquiry as he considers necessary, comma, direct the applicant to deposit such further sum, if any, within the time specified by him, and on such sum being deposited, comma, to make an order that the amount of the consideration money, together with such other sums as are proved to have been paid by the transferee, plus 10% of the consideration be paid to the transferee or the person interested out of the money in deposit, and the remainder being refunded to the applicant. Full stop. In the present case, comma, the petitioner deposited the amount, initial amount, to the tune of rupees 11,459 on the petitioner's assessment of the actual consideration which passed between the parties. Full stop. Accordingly, comma, an issue falls for consideration as to whether before any ascertainment under section 9, comma, which has been apparently done by the learned trial judge in the present case by directing the balance amount to be deposited, comma, it could be said that the preemption application itself ought to have been deposited. Full stop. Next para. A second question which arises is whether the appellate court ought to have remanded the matter to the first court, comma, granting an opportunity to the petitioner to deposit the entire consideration amount as reflected in the sale deed sought to be preempted, along with 10% interest, along with 10% additional amount, comma, and relegated the matter to the trial court till the stage just before passing of the preemption order, in order to enable the petitioner to deposit such amount for getting a proper preemption order. Full stop. Next para. The revisional application shall be heard on the above questions. Full stop. Accordingly, the petitioner shall serve copies of CO 3645 of 2024 on the opposite party, indicating that the matter shall be listed for contested hearing before the appropriate bench.
Motion, my lord, as the motion, my lord. This is the short matter.
No, no. For contested hearing before the appropriate bench in the monthly list of February 2025. Full stop. On the returnable date, comma, an affidavit of service shall be filed by the petitioner. There is no scope of interim order.
No.
Bas. Next. About 55. Yes, Mr. Bhattacharya. There is no caveat. Yes. What is the matter? Mr. Bhattacharya, please take the microphone. Yes.
Facts of the case is very short.
Ad interim injunction has been refused.
It was both the facts of the case, no? Bharat Chandra is the owner.
Mr. Bhattacharya, please take the microphone a bit closer. Yes.
Bharat Chandra is the owner. He executed a deed of gift in favor of me in the year 1998.
Deed of gift?
Deed of gift. And I am the grandson of the Bharat Chandra. But,
he executed in favor of you?
You. Now, Lord, in the year 2024, when I possessed the property, the defendant came and he told that in the year 1981, Bharat Chandra sold me entire property.
Sold him that property?
She is the daughter of the Bharat Chandra. Now, Lord, I filed the suit.
For?
Declaration and injunction.
What declaration did you seek?
Declaration that I am the owner of the property.
If you don't challenge the sale deed, that's prior to your gift deed.
But I do not know whether he has the property has been sold to her or not.
In your plaint, you have stated that she raised she asserted her sale deed.
Yes, that is.
Then without a prayer for cancellation of that deed, you don't have a.
But I have that I have not done. But my injunction application is not to interfere with my possession because I am in possession since 1998, and not to change the nature and character, and not to transfer. Now, my lord, your lordship, can you see page 32?
Yes, 32.
In the middle portion, considering the above facts and circumstances, and on perusal of the documents, and this court finds that the plaintiff document of title is a deed of gift executed by grandfather in favor of him in the year 1998, whereas the BC rule deed is of the year 1981, which is allegedly executed by Bharat Court in favor of the defendant on the basis of misrepresentation. Prima facie, it is seen that defendant documents of title is prior to the documents of plaintiff. There is no prima facie case at present, as credibility of BC rule deed is subject to evidences. The record of right is not produced. The apparent fact of possession is also not. But I am in possession since in the year 1998.
But Mr. Bhattacharya, if your possession is not substantiated by title,
No,
because
but
1981 deed is prior.
Not 81 prior, but not
You don't have a title. How can you get injunction? Only a valid title
only
holder can get.
nah, it should be decided, but not only.
No, if your
thing not-
possession
it
is
will not.
possession is not lawful,
It will not change the nature and character of the property, because not he can any time change, any time sell the property.
Let us see.
And Lord,
let us see in the plaint whether you have challenged that deed of 1981. If you
Your
don't
Lordship, can you
challenge,
see,
plaint reliefs are at page 16.
plaint Lord, page 20 and page, yes, page 16. Brought the prayer portion.
Where have you challenged that deed? Nalisi Dolil, yes. Vitiated by misrepresentation, you have said. You have challenged it.
Yes. And the appeal court also refused on the ground that I filed the appeal 1.5 months after.
1.5 months after what?
Yes. Your Lordship, kindly see order dated 3rd June 2024, next page. Last page, Your Lordship, kindly see. Last page. Middle person, before parting this court, must note the appeal. Misappeal was filed on 15th April 2024. Before parting this court, must note that the and the applicant plaintiff has come to move ad interim after a lapse of more than 1.5 months. That goes to show that
So
he
both
has
the
no
courts have
urgency.
held that you have failed to show that you have current possession of the property.
Yes,
because
but
hard sale deed is prior.
Prior, maybe, but he has not. She has not come to since 1981. She has not come to the brought in question till 24.
So you should have produced the records of rights at least
But
to show your possession.
want to change the nature and character. That can be, and not to transfer. Not to transfer. If she transfer, then again some multiplicity of suits.
Where is your injunction? Let us see whether
Injunction, Your Lordship, can you say page 27? Prayer.
Yes.
Nature and character and the position also. Nature and character on
The present revision has been filed by the plaintiff in a suit for declaration that a sale deed of 1981 executed in favor of the defendant / opposite party is vitiated by misrepresentation, also asserting the plaintiff's right in the property and seeking consequential permanent injunction. In the said suit, an injunction application was filed. An application was filed for temporary and ad interim injunction, restraining the defendant from changing forcibly the nature and character as well as possession of the suit property, and/or from disturbing the peaceful possession of the petitioner in respect of the said property. Next para. The present revision has been taken out against a judgment of concurrence whereby both the courts below were pleased to refuse ad interim injunction on the premise that the question as to the validity of the 1981 deed, comma, which is prior to the 1998 gift deed in favor of the plaintiff, on which the plaintiff claims title, comma, shall be decided at the final hearing of the suit on evidence, and also that the plaintiff failed to show any prima facie proof of possession of the plaintiff in respect of the property. Full stop, next para. At the stage of grant of ad interim, ex parte ad interim injunction, comma, the court has to proceed on the premise that the averments made in the injunction application are sacrosanct. Full stop, next para. Although no proof of possession of the plaintiff was produced in the court below, comma, in view of an arguable case having been raised regarding the deed of 1981 in favor of the defendant being vitiated by misrepresentation, comma, the courts below, comma, prima facie, comma, ought to have granted ad interim injunction at least to the extent that the opposite party does not transfer and change the nature and character of the suit property during pendency of the temporary injunction application. Full stop, next para. Accordingly, CO number 3666 of 2024 shall be heard on the above questions. Full stop, the petitioner shall serve a copy of the revisional application on the opposite party, indicating that the same will be listed in the monthly list of February before the appropriate bench. Full stop, the petitioner shall file an affidavit of service on the next returnable date. Full stop, the opposite party and or her men and agents shall remain restrained by an order of injunction from changing the nature and character of the suit property and or from selling, transferring, alienating, and or creating any third party interest in favor of a third party till February 28, 2025 or until further order, comma, whichever is earlier.
Get.
Any other revisional application where only the there is no caveat either or both sides are present?
Item number 22, my lord.
Just give the numbers.
Item number 40, my lord.
Item number
22, my lord.
Item number 60.
60.
Item number 40, my lord.
22, 40, 60. What is? 56,
45. Lordship 32.
Lordship 15. Your Lordship, item number 28.
My lord, 65 without carry.
Your Lordship, item 28. 28.
I have recorded 14, 15, 22, 28, 32, 40, 45, 48, 56, 60, and 65.
Kindly add 66.
60?
66.
66 also. Yes.
33. 33, no caveat.
67 also, no caveat.
61. No
Thir-
caveat.
33. Let us take up these matters first, then after recess we'll continue. তাহলে একটু নোট করে নিন 22 28 33 32 33 28 এর পর 32 33 40 45 48 56 60 65 66 67 এগুলো আগে কল করুন, এগুলো হয়ে যাওয়ার পর বাকি 14 থেকে শুরু করুন, বাকি ফাইলগুলো বার করতে থাকুন। 57 let us take up the matters which have been mentioned first. Yes, call on the list. Acha, very well, call on the list. We'll call on the list serially. Let us call on the list serially from 2. Item 2 থেকে serially call করুন। Passover. 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 Same. Same. Passover. Passover.
Petition. There is other side is also there.
So Passover.
Yes.
I'm passing over this. Yes. Passover. There is no caveat.
There is no caveat.
No caveat.
No caveat.
9টা তাহলে দিন।
বিনোদ বিহারী দাস।
It's an application for direction be given upon the trial court for expeditious hearing of this matter. Sir, considering the age of the litigant, say
You are the landlord.
I am the landlord. Suit for reasonable requirement for eviction.
When was the suit instituted?
Sir, 2012, Your Honor.
2012. What is the
Yes.
stage of the suit?
Sir,
7-2 decided.
7-2 decided. Now the suit is going on for commission. Sir, commission work. Commission work is going on.
Any application is pending.
No, Your Honor.
In view of the innocuous nature of the prayer, notice of prior notice is not being directed on the opposite party. Full stop. Next para. The petitioner, what is the age of the petitioner?
83 years.
The petitioner is an octogenarian and being the landlord filed the present suit for eviction long back in the year of 2012. Full stop. The matter has crossed the stage of adjudication on applications under section 7 within bracket 1 and within bracket 7 7(1) and 7(2) of the West Bengal Premises Tenancy Act 1997, and commission work is now going on. Full stop. Learned counsel for the petitioner, on query of court, submits that no further interlocutory application is pending. Full stop. Next para. Keeping in view the advanced years of the petitioner and the long pendency of the suit, CO number 2314 of 2024 is disposed of by requesting the learned civil judge, Junior Division at Bidhannagar, District North 24 Parganas, to dispose of ejectment suit number 66 of 2012 pending before the said court as expeditiously as possible, positively within within the month of December 2025. The parties shall act. The parties and all concerned shall act on the server copy of this order without insisting upon prior production of a certified copy. Right. Next. Not Passover. Same. Passover. Passover. 14. 15টা ready রাখবেন এরপরে yes ma'am, what is the matter?
Matter for expeditious disposal. On earlier occasion on 3/9/2017, the petitioner got an order from this bench also, and after that at page 59, Lordship.
The suit is for?
Suit is for repairing and title suit also.
No, title suit is for what?
Injunction, Lordship.
What is the stage of the suit? Any application is pending?
Yes, Lord.
What application is pending?
Lordship, since 2019. No, 2009.
What application is pending in the suit? Is there any pending? What is the stage of the suit? Evidence has started?
No, Lordship. Not yet.
What applications are pending in the suit? You have to know those. You cannot direct off the cuff just like that.
Lordship, on last 11/10/2023, plaintiff filed a petition under section 151 of CR.
Your repair application is pending.
Yes, Lordship. Repair application is already, you have grant order on 3/9/2017 at page 59 that the learned judge conclude the matter on 1 month within the date of communication. But on 5/3/2020, the learned judge allowed the repairing application with a stigma that there is no the plaintiff cannot raise any pakka construction.
So we are not sitting in judgment over that. You are asking for an expeditious disposal of the suit itself.
And
So repair application, whatever order has been passed, has been passed.
till that the petitioner did not get any relief. He is the
Repair application has been decided. Disposal.
decided, but there is no pakka construction.
Are you challenging the repair order?
No, I am just seeking for a expeditious disposal.
Any other application is pending? You should have disclosed that. In view of the innocuous nature of the prayer, no prior service of notice on the opposite party is being directed. Opposite parties is being directed, pushed up. Then at counsel for the petitioner points out that on September 3, 2019, this court had passed a direction on the learned trial judge to rehear and decide afresh the pending repair application expeditiously. Pusab, it is submitted that although the repair application has been decided, comma, no effective order for making Paka construction was passed in favor of the petitioner. Pusab, next para. Be that as it may, comma, learned counsel submits that since the suit is pending since the year 2009, 89 years,
Petitioner is now in it.
and the petitioner is about 89 years of age as well as physically paralyzed, comma, the suit may be directed to be decided early. Who's up next para? In view of the above circumstances, comma, CO 2557 of 2024 is disposed of by requesting the learned civil judge bracket senior division second court at Diamond Harbour district South 24 Parganas to dispose of title suit number 188 of 2009, comma, pending before it, comma, along with connected pending applications, comma, if any, comma, as expeditiously as possible, comma, positively within the month of December 2025. No orders to cost. The parties and all concerned shall act on the server copy of this order for the purpose of compliance without insisting upon prior production of a certified copy.
Lordship, I appear for the petitioner, my lord, expeditious disposal, ejectment suit 2030. 7172 application was initially dismissed, thereafter placed on ex parte board. Again, that order was recalled. Again, on the 19th of November, it was again dismissed. Now the stage is for framing of issues. Lordship, he is the plaintiff, my lord, he is 72 years old. Lordship will kindly consider.
In view of the innocuous nature of the prayer, no prior service of notice on the opposite party is being directed. Pushed up. The plaintiff in an eviction suit is in her 70s. Pushed up. Although the application under section 7 within bracket 2 has already been decided, comma, the suit has not yet reached the stage of peremptory hearing. Pushed up. Keeping in view the advanced age of the petitioner and the long pendency of the suit since 2013, comma, CO 2601 of 2024 is disposed of by requesting the learned civil judge junior division second court at Serampur district Hooghly to dispose of title suit number 52 of 2013 pending before it as expeditiously as possible, comma, positively within the month of December 2025. Pushed up. No orders to cost. The parties and all concerned shall act on server copy. Thank you.
Lordship, 71 and 72 had been dismissed.
আচ্ছা, disposed of যেখানে বলছি 7 dismissed. Thank you.
I'm grateful.
Thank you. Not to Passover. Same. Same.
Item number 90.
Same.
Item number 20.
Passover.
Item number 21.
My lord, 21, my lord, I am for the petition. It's for expeditious hearing, suit of 1990, suit for partition.
Let the file come. Let the file come. Expeditious hearing, suit of
1990.
only. Very recent.
My lord, framing of issues.
Why
not
is it
yet
pending
done.
for so long? There were revisions in between.
My lord, no, there were, my lord, somehow it was pending. I have annexed all the orders. No reason, only framing of issues. Ultimately, in 2021, an application under section 151 was filed for implementation
file.
order of. My lord, in 2021, an order of one.
You are Sudeep Kole.
My lord.
Yes.
He is one of the defendant. His father was the original defendant. His
What
father
is the suit
died.
for?
Partition.
Partition suit preliminarily not yet passed.
Framing of issues not yet.
2021, what happened?
An application under section 151 for implementation of order of injunction with police help was filed.
By you?
By me.
By
That is also pending by one of the defendants. There are several defendants, my lord. That is also pending, and framing of issues also not yet issues.
In view of the innocuous nature of the prayer, no prior service of notice on the opposite parties is being directed. Push up. The petitioner, learned counsel for the petitioner submits that the present matter arises out of a partition suit of the year 1990, which is still at the issue framing stage, full stop, also, comma, an application filed in the year 2021 by the petitioner under section 151 of the Code of Civil Procedure for implementation of an injunction order by police help is also kept pending. Full stop, next para. In view of the inordinate delay in disposing of the interlocutory application as well as the suit, comma, the prayer for early hearing is justified. Full stop, accordingly, CO 3088 of 2024 is disposed of by requesting the learned Civil Judge Senior Division, Third Court at Howrah, District Howrah, to dispose of the pending application under section 151 filed by the petitioner and or any other pending applications, if any, as expeditiously as possible, comma, positively within 4 weeks from the date of communication of this order to the trial court. Full stop. The court shall also make all endeavor to dispose of the suit itself as expeditiously thereafter as possible, comma, preferably within March 31, 2026. Full stop. The parties and all concerned shall act on the server copy of this order without insisting upon prior production of a certified copy, no rest to cost. We have given till March because if there's a preliminary decree and all. Next.
22, my lord, I beg to appear on behalf of the petitioner, my lord. Petitioner is the plaintiff, petitioner.
Let the file come.
Suit for eviction and recovery
This
of
CO number 3130.
P130, my lord.
No caveat.
No caveat, my lord. Expeditious hearing, my lord.
Expeditious hearing.
My lord. 7-1 applications is disposed of. 7-2 application is pending. Is suit for.
No, then we cannot direct the suit to be disposed of. 7-2 has to be decided because if it is decided,
Is pending since to
we'll direct the 7-2 to be decided immediately. We'll decide that only. In view of the innocuous nature of the prayer, no prior service of notice on the opposite party is directed. Full stop. The petitioner is the plaintiff in a suit for eviction instituted in the year 2018. Full stop. Since then, comma, it is still pending at the stage of disposal of the application filed by the defendant opposite party under section 7 within bracket 2 of the West Bengal Premises Tenancy Act 1997. Full stop. In view of the inordinate delay in deciding the application under section 7 within bracket 2, comma, this court is of the opinion that that appropriate directions for expeditious hearing for expeditious disposal ought to be passed. Full stop. Accordingly, CO number 3130 of 2024 is disposed of by requesting the learned Civil Judge Junior Division, 4th Court at Alipur, District South 24 Parganas, to dispose of the pending application under section 7 within bracket 2 of the West Bengal Premises Tenancy Act 1997, filed in connection with title suit number 56 of 2018 in the said court as expeditiously as possible, comma, positively within 4 weeks from the date of communication of this order to the court below, to the learned trial judge. For sub next para, it is made clear that the learned trial judge is expected to take up the suit itself for disposal thereafter and make all endeavor to dispose of the suit as expeditiously as possible. Full stop. The party shall act on the server copy of this order without insisting on prior production of a certified copy and no rest to cost.
My lord, item number 23, my lord, the suit for eviction. So it
So for
was
the petitioner, there is any caveat?
My lord, there was a caveat and my lord, like,
My lord, only humble request, my lord, matter suddenly came before your lordship.
my lord,
I am not well prepared, my lord, to be true, my
but
lord.
kindly see the last order passed by Honorable Justice Basu, while his lordship was taking the matter. And they had again made this replica prayer before that honorable court and said sought for accommodation. 13th September order, my lord, of this year, of last year.
Yes.
But the
No. You are aware of the matter. It came before this bench or that bench is immaterial. The matter is pending before Justice Basu since long.
Pending, my lord.
No. No question of time. Yes, what is the matter? What is your brief? You have your brief?
No, my lord. There's another brief, another matter, my lord. Only one day, my lord, I will.
No, we'll give you till 2 p.m. Come back at 2. 2 p.m. I'll take up the contempt matter first, then take up this matter. এই ম্যাটারটা 2 p.m. এর সেকেন্ড ম্যাটার হবে আফটার দি কন্টেম্পট অ্যাপ্লিকেশন। ঠিক আছে, এক তারপর এটা।
Both the matters, my lord, 23 and 24.
23, 24 দুটোই সেম। ওই একের পরে ওইগুলো নেবো 2 p.m. 2 p.m. He is appearing for the other side in both?
In both. দুটোতেই তো।
25, my lord, I'm the petitioner.
Caveat?
No caveat, my lord. For expeditious disposal, my lord. Application under section 25 of the Guardians and Wars Act 1890, my lord. Section 12 application dispose of visiting rights has been given, but my lord, thereafter from since 2013, 18 from 2018, my lord.
The present, in view of the innocuous nature of the prayer, no prior service of notice is directed. Push up the petitioner. The present matter arises out of miss case number 190 of 2018 within bracket Act 8 bracket closed, which is for custody of the minor child of the parties. Full stop. Learned counsel for the petitioner submits that an application under section 12 has been disposed of by granting visitation rights. Full stop. However, the main matter has been kept pending since the year 2018. Full stop. Keeping in view the nature of the application and the implicit urgency involved in a custody matter, this court is of the opinion that the matter ought to be decided expeditiously. Full stop. Accordingly, CO 3145 of 2024 is disposed of by requesting the learned additional district judge, third court at Barasat, district North 24 Parganas, to dispose of miscellaneous case number 190 of 2018 within bracket Act 8, Roman 8, as expeditiously as possible, positively within December 31, 2025. Full stop. No orders to cause. The parties and all concerned shall act on the server copy of this order without insisting upon prior production of a certificate.
My lord, I appear on behalf of.
Is there any caveat?
No, my lord.
Well,
But expeditious disposal, my lord. Suit was
so
filed.
many
my lord.
expedients. What will the trial courts do? I mean, they have so many matters on their roster.
In the year 2006, my lord, the suit was filed and evidence is complete.
What is the suit for?
Suit for
eviction.
Eviction, my lord.
What is the stage of the suit?
Already completed.
Evidence complete. For argument, my lord, several dates, and they have filed a misapplication.
In what misapplication?
Order 9 rule 30.
Order 9 rule 30.
Order 9 rule 13. Expertise degree was obtained by you.
No. Contested. They have contested lordship.
Either of you argue. Either you or him. Choose who will argue. How can there be an order 9 rule 13 if there is no expertise degree?
I'm sorry, my lord. At 2, I thought that the matter will be taken up at 2 p.m. But
Lordship, may I submit?
Yes.
Lordship, may I submit, Lordship? Lordship,
What about the order 9 rule 13?
Order 9 rule 13 misconceived application.
You are seeking now. Why are you asking for early disposal of the suit?
Because the suit has been pending since April 2024, Lordship, for argument and delivery of.
This is CO number 3206.
Yes, Lordship.
Mohammed Yunus Ansari.
Yes, Lordship. And the application.
How can there be an order 9 rule 13 application?
Yes, Lordship.
Yes.
Lordship, order 9 rule 13, that is misconcept.
It may be misconceived. That has to be decided by the court.
Yes,
the suit was decreed expert in your favor.
I'm only my only.
Show me the order 9 rule 13 application, please.
Lordship. There is page number 120, Lordship. And on 15th of this month, Lordship, this application has been, and my maintainability petition also.
The suit was not decreed expertise.
No.
Suit is pending.
Suit is pending. It has been contested, and the stage was for delivery of the judgment.
What are you saying?
Yes, Lordship.
for arguments.
May-
application
Petitionটা দেখি একটু আমি একটু applicationটা দেখি।
Where have you stated in your revision that no expiry degree was passed?
On 4/4/2011, expedited an order is passed. In that
What you have in para 11 you have what was restored? In para 11 you have stated at the stage of final argument of the suit by suppressing earlier order dated 4/4/2011. What was that order? In proceeding under Order 9 Rule 13. So there was an earlier Order 9 Rule 13. No, please serve a notice on the other side and come back.
There was and it has been restored that.
Serve a notice on the other side and come back. Certain peculiar points have been raised in the present. Certain peculiar points have been raised in the present application under Article 227 of the Constitution of India.
Lordship, my
Push up.
simple prayer is that let their Order 9 Rule 13 along with my maintainable petition be heard expeditiously along with the suit. That is my simple prayer.
Along with the suit. Order 9 Rule 13, if the Order 9 Rule 13 is dismissed, how can the suit be?
Since the
বললাম কোথায় থামলাম?
Certain peculiar points have been raised in the present application under Article 227 of the Constitution of India.
So learned counsel for the petitioner submits that although an Order 9 Rule 13 although an application under Order 9 Rule 13 of the Code of Civil Procedure is pending, comma, the same is misconceived and the maintainability petition has been filed. Push up, it is also submitted that there was no ex parte order passed at any stage. Push up, next para, in view of such contradictory submissions, comma, the opposite party is required to be heard before passing any orders. So accordingly, the petitioners shall serve copies of CO 3206 of 2024 on the opposite parties, indicating that the matter shall be listed under the same heading on February 7, 2025, when the petitioners shall file an affidavit of service to that effect. 7th February, come back, service. This court. Next matter. Next matter.
Petitioner, my lord. There is no caveat. Expeditious disposal of suit for eviction and recovery of possession. Suit filed in 2010, my lord.
Stage of the suit.
Dated 7172 not disposed of due to pendency of
You can direct only that.
Section 5 of the limitation.
That is Section 5 along with 7. So that I can. Learned counsel for the petitioner submits. আচ্ছা না, তার আগে একটা লিখ। In view of the innocuous nature of the prayer made, comma, prior service of notice on the opposite party is not being directed. Stop. Para. The plaintiff in an eviction suit filed in the year 2010 has filed the present application under Article 227 of the Constitution of India, seeking expeditious hearing of the matter. Push up. It is submitted that an application under Section 7 within bracket 1 and 7 within bracket 2 of the West Bengal Premises Tenancy Act 1997, comma, along with an application under Section 5 of the Limitation Act are pending for an inordinately long period, comma, thereby delaying the disposal of the suit. Full stop. In such view of the matter, comma, and also keeping in mind that the petitioner is in his 60s, comma, 60s words 60s, comma, CO number 3209 of 2024 is disposed of by requesting the learned Civil Judge Junior Division, First Court at Baruipur, District South 24 Parganas, to dispose of the pending applications under Section 7 within bracket 1, comma, 7 within bracket 2 of the 1997 Act, as well as Section 5 of the Limitation Act, as well as other pending applications, comma, if any, comma, filed in connection with title suit number 4 of 2010 pending before the said court, as expeditiously as possible, comma, positively within 4 weeks from the date of communication of this order to the said court, full stop. There will be no rise to cost, stop. The parties and all concerned shall act on the server copy of this order without insisting upon prior production of any certified copy for the purpose of compliance.
Item number 28. Your Lordship, I'm for the petitioner. There is no caveat, Your Lordship. This is my application for expeditious disposal. Your Lordship, the suit was filed in the year 2024. However, Your Lordship, my injunction application under Order 39, Rule 1 and 2 has been pending since almost a year. The urgency is that I have been thrown out from my own premises. That's why
Ad interim order has been passed, was refused.
the injunction application has not even been heard, Your Lordship.
Cannot be, it's heard on the first date.
Your Lordship, kindly sees.
Have you annexed the order sheet?
Yes, Your Lordship.
Let us see that. That
There
would
was
be
a caveat, Your Lordship. That's why.
That's what it is.
However, it was served. It was served prior only, Your Lordship. However,
Very well,
again,
very
Mr.
well.
Sir,
In view of the innocuous nature of the prayer, comma, prior service of notice on the opposite parties is not being directed. Full stop, next para. The plaintiff stroke petitioner filed the suit for declaration, and consequential reliefs in the year 2024, comma, on March 28, 2024 to be precise. Full stop, along with the suit, along with the plaint, comma, an injunction application under Order 39, Rules 1 and 2 of the Code of Civil Procedure, comma, read with Section 151 of the Code, comma, was also filed by the petitioner seeking injunction. Full stop. No orders were passed at the ad interim stage in view of a caveat having been lodged. Full stop. It is submitted by learned counsel for the petitioner that although the caveator has been served long back, comma, the application is not being taken up for hearing since then. Full stop. Keeping in view the long pendency of the interlocutory application for injunction for about a year, comma, the ends of justice required that the said application is decided expeditiously. Full stop, next para. Accordingly, CO number 3261 of 2024 is disposed of by requesting the learned civil judge, senior division, second court at Barasat, district North 24 Parganas, to dispose of the application pending under Order 39, Rules 1 and 2, comma, read with Section 151, comma, of the Code of Civil Procedure at the behest of the plaintiff stroke petitioner in connection with title suit number 323 of 2024 pending before the said court as expeditiously as possible, comma, positively within 6 weeks from the date of communication of this order to the learned trial judge, comma, giving opportunity to the defendant stroke opposite parties to file written objection, comma, if any, within the said time frame. Full stop. There will be no orders to cost. The parties and all concerned shall act on the server copy of this order without insisting upon prior production of a certified copy for the purpose of compliance.
grateful, Your Lordship.
Not today. Passover. Passover. Same.
Your Lordship, 31, Your Lordship, I am paying for not today, Your Lordship. Mr. Rahul Karma.
32.
31, Your Lordship.
31, not today. Rahul Karmakar is for the petitioner.
Yes, he's out of.
আচ্ছা 31 এ একটা order record করুন on the prayer of the petitioner the matter is adjourned for the day. 31. 32 Mr. Lahiri, come.
Lordship, I appeal for 32 for expeditious hearing of the matter. Lordship, if the matter is pending from 2022.
32 টা
The Lordship, the matter relates the petitioner filed a suit for eviction, injunction, and means profit against the defendant.
Eviction under 97 Premises Tenancy Act.
Yes, Lordship, 721 and 2.
7(1) and 2 is pending.
Yes, Lordship is pending. He is on hearing stage. The petitioner preferred an application. The application was last heard in the year 2022.
Petitioner preferred what application?
An application for interim injunction under Order 39, Rule 1 and 2. Read with Section
So
1.
7(1) and 2 as well as injunction application, these two are pending.
Yes, Lordship.
So we'll direct those two applications to be decided.
To be decided expeditiously, Lordship.
Learned counsel for the sorry. প্রথম line say paragraph টা হবে in view of the innocuous nature of the prayer. ওটা same. Next, the present application under Article 227 of the Constitution of India arises out of an eviction suit filed by the plaintiffs stroke petitioners for eviction suit বললাম
Suit for eviction.
filed by the plaintiffs petitioners. Full stop. Learned counsel for the petitioners argues that an application filed by the petitioner for injunction in connection with the said eviction suit, as well as the defendant apostrophe application under sections 7 within bracket 1 and within bracket 2 of the West Bengal Premises Tenancy Act 1997 are pending since long. Full stop. Next para, I find from the records that the inordinate delay in disposal of such interlocutory applications justified expeditious hearing of those. Full stop. Para. Accordingly, CO 3329 of 2024 is disposed of with a request to the learned civil judge junior division first court at Barasat district North 24 Parganas to dispose of the pending interlocutory applications, including the application under section 7 within bracket 1 and within bracket 2 of the 1997 Act and the injunction application filed by the plaintiff as expeditiously as possible, positively within 6 weeks from the date of communication of this order to the learned trial judge. Full stop. No order as to cost. The parties and all concerned shall act on the server copy of this order without insisting upon prior production of a certified copy.
This is also for expeditious hearing, my lord. 1994 for letters of administration. 1996 it was renumbered. Page 120. All the evidences were closed and it was fixed for argument.
When were the evidences closed, Mr. Lyri?
Page 120.
Give me the date.
15th November 2016. Page 120.
Then
thereafter, my lord, it was fixed for arguments. My lord, several dates were given, my lord, where, my lord, the arguments commence. There is an order.
Probate, you said, or letters of administration?
It was contested.
Probate.
Thereafter, my lord,
in view of the innocuous nature of the no interlocutory application is pending.
No interlocutory. As of today, it is fixed for evidence of the handwriting expert. The handwriting expert's report was obtained. Thereafter, during the course of argument, it was discovered that the handwriting expert's report is, my lord, misplaced. Thereafter, another.
So there is no pending application.
No, it's no pending application.
In view of the innocuous nature of the pratham paragraph to common, the present application under Article 227 of the Constitution of India arises out of a contested probate proceeding initiated originally in the year 1994 and thereafter turning contentious and renumbered. Full stop. Next para. Learned counsel appearing for the petitioner submits that the probate case is now pending at the stage of peremptory hearing and the examination of the handwriting expert is going on. Full stop. It is submitted that such application was taken out at the stage of arguments. Full stop. Next para. Accordingly, it is evident that the suit is at a mature stage and is pending inordinately. Full stop. Accordingly, CO 3367 of 2024 is disposed of with a request to the learned additional district judge, 11th court at Alipur, district South 24 Parganas, to dispose of original suit number 1 of 2001 pending before the said court as expeditiously as possible, positively within August 31, 2025. Full stop. No orders to cost. The parties and all concerned shall act on the server copy of this order without insisting upon prior production of a certificate.
The dependent petition.
No caveat, Mr. Bhatt. Yes.
Dispose of the injunction application that was obtained in the year 2009. Who proceeded for declaration and permanent injunction?
Injunction application is pending from 2009.
2009. And next date was on 13 December. And 13 days, as told by my client yesterday.
Last 13 December.
Last 13 December. And that has been, that was initially Civil Judge Junior Division, Barasat, First Court Barasat. Now have been transferred to Second Civil Judge Junior Division. But again, that has been adjourned. And interim order.
No, but your prayer says First Court. So,
First court now is you have been shifted to second court on 13 December. But prior to that, I filed this application.
so you are sure that it has been shifted?
Yes.
Very well. In view of the Pratham paragraph common.
One thing more, my lord, he has also filed an application for contempt in 2000 immediately after.
You filed.
No, plaintiff after status order passed. That is also still pending.
Oh, it's their injunction. They are
Filed right here.
their contempt application.
Contempt application. Status order.
Very well. Learned.
And that is fixed on 3rd May 2025.
In view of the innocuous nature of the prayer made, Pratham paragraph. The present application under Article 227 of the Constitution of India has been filed at the behest of the defendant in a suit for declaration and consequential reliefs. It is submitted by learned counsel that the injunction application and application under Order 39 Rule 2 capital A of the Code of Civil Procedure filed in connection with the said suit by the plaintiff's opposite parties has been kept pending inordinately. Accordingly, CO 3445 of 2024 is disposed of with a request to the learned civil judge, junior division. Sorry, এই sentence থেকে accordingly paragraph কেটে দিয়ে last paragraph কেটে নতুন করে করো. It is also submitted on behalf of the petitioner that on the last date, that is December 13, 2024, the suit has been transferred from the first court of learned civil judge junior division to the second court of learned civil judge junior division at Barashat. Next para. Accordingly, CO 3445 of 2024 is disposed of with a request to the learned civil judge junior division second court at Barashat district North 24 Parganas to dispose of the pending applications, including the injunction application and the application under Order 39 Rule 2 capital A of the Code, pending in connection with title suit number 215 of 2009 before the said court, as expeditiously as possible, positively within 6 weeks from the date of communication of this order to the said court, no order as to cost. The parties and all concerned shall act on the server copy of this order without insisting upon prior production of a certificate. We hope you have filed your objection to the injunction.
Immediately in 2009, in both the applications.
I appear for the petitioner, my lord.
Yes.
There is no caveat. Expeditious disposal of ejectment suit number 16 of 2015, my lord.
Stage.
There is a application under Order 39 Rule 7. Commissioner was appointed, but commissioner still did.
No, 7172.
No, 7172, he did not file it.
Acha, 397 is pending.
That has been disposed of. Commissioner was appointed. Commissioner till date has not filed report, praying for adjournment.
Pratham paragraph common in view of innocuous nature. The present application under Article 227 of the Constitution of India arises out of an ejectment suit, out of an eviction suit filed in the year 2015. It is submitted by learned counsel for the petitioner, learned counsel for the plaintiff stroke petitioner. Plaintiffs stroke petitioners that the suit is now pending at the stage of the suit is now awaiting filing of report by the commissioner appointed by the court, and the peremptory hearing is yet to begin. No other pending application. It is further submitted that there is no other pending application in the suit. Accordingly, in view of the inordinate delay, CO 3489 of 2024 is disposed of by requesting the learned civil judge junior division first court at Alipur district South 24 Parganas to dispose of ejectment suit number 16 of 2015 pending before the said court as expeditiously as possible, positively within March 31, 2026. In order to implement the order, the learned trial judge will be at liberty to pass necessary directions on the commissioner to file his or her his report expeditiously. Next para, no orders to cost. The parties and all concerned shall act on the server copy usually. No, we have passed over whatever matter. Now we'll go on calling and at the end we'll go back. We have not made not today. We'll continue after 2. 2 PM কিন্তু প্রথমে কন্টেম্পটা, তারপরে যে দুটো ম্যাটার রেখেছিলাম পাস করব। Yes.
Your Lordship, as the content, Your Lordship, the appeal was taken up for hearing on last month, on the last. and
Yes.
thereafter-
Milords, I'm sorry, may I, Milords, seek your leave to mention?
Sorry, I'll just hand over.
Yes.
I'm so sorry.
Mr. Gopi, you are present on that date.
Yes, my lord, I was present.
What happened in the appeal?
Yes, Your
My lord, the appeal was, delay was condoned over there and the learned court allowed for pray for deferment.
Yes, the Honorable Chief Justice has fixed the matter on this Monday. And also your Honorable Chief Justice has made a request to this Honorable Court. If your Lordship sees at para 13, Your Lordship.
Good. When the matter is called on for hearing, comma, an order, a server copy of an order dated January 15, 2025, passed in MAT 1029 of 2024, comma, that is the appeal against the parent order, comma, is placed before the court. Push up, it is evident from the said order that the appeal was directed to be listed for admission on January 20, 2025, and a request was and a liberty was granted to the appellant to place the said order before this court and pray for deferment of further proceedings in the contempt application, and also to request the contemptor to appear virtually, since as on date he is working as Deputy Inspector General in Murshidabad. Push up next para. In view of such order, comma, the present application for contempt is deferred till January 31, 2025, when it will be listed at 2 p.m. Full stop. For the time being, comma, the appearance of the alleged contemptor before this court is dispensed with, subject to further orders being passed later. The copy of the order handed over in court to be kept on record.
Since there are holidays, can it be just 1 week?
I can't hear you. See?
There are holidays, can it be 1 week after? Just 1 week.
I've given you for fortnight, 31st. That's why. The 1 week ends on 24th. I've given you 1 week extra. Please.
Okay, thank you.
Milords, may I seek your Lordship's leave, Milords, to mention?
Yes.
Milords, I had mentioned a contempt application in the morning for Circuit Bench Jalpaiguri. Milords, this needs to be withdrawn. If your Lordships may direct this to
Yes,
be
yes.
listed at the earliest.
Just give the number that will be listed to be mentioned.
Milords, will this appear on next Friday, Milords, if my understanding is correct?
Next Friday, but not next Friday, on 31st. I'll be taking up this matter next on 31st. So you give the number in the inbox. Have you given the number?
Yes, Milords, I'll give that. Milords, is there any possibility to do it earlier, Milords? It's just for withdrawal.
No.
Okay, grateful, Milords. I'm obliged.
31st date deven listed to be mentioned.
File number 23.
Yes.
And for the opposite, the suit for eviction, suit of 2009, eviction decree was passed in 2011. Thereafter, my lord, within time, my lord, the put to execution, the defendant tenant, without even challenging despite having the knowledge of the suit and without even challenging it, they have filed an application under order 47, under section 47 of CPC. And the learned court below held that since the property was a 2-storied building, now it has been 5-storied, then the decree is not executable. And he has allowed the application, and this is all allowed.
What is that order?
My lordship.
Why have you annexed the entire order sheet? You should have annexed the last one.
It is, my lord, I believe.
No, the entire order sheet you generally apply for the anyway. Let us come to that. The eviction degree was in respect of which floor?
But they they were having two separate shop rooms, two
Shop
tenants, two shop rooms. So in respect of their shop rooms.
Shop rooms are on the ground floor.
On the ground floor.
So why entire building? Only on the ground floor?
Only on the ground floor, my
The
lord.
strategy for the other side.
No, my lord, I'm led by him.
No, the eviction was only regarding the shop rooms on the ground floor.
No, my lord, yes, my lord, the shop rooms on the ground floor.
Section 47 allowed because the more stories came up.
Yes.
Let just.
No, not just that. My lord, they allege that
Yes.
during my lord pendency, my lord, they had their section 47 is that they've entered into an agreement and that degree becomes void. Kindly have a look at exactly.
Final order with reasons, let us come.
Kindly kindly have a look at page
Yes. You're
application at
encroaching
65.
upon another suit because you the title, yes. So we'll come to the third last page of the order, final order with reason of the impugned order first. Let us.
Kindly just once, my lord, look at the 47. What is the prayer?
Yes.
Lord, at 65. 69. It starts from 65. It's at 69. Just looks at that. I'm not even reading it for your lordship's, my lord, consideration. My lord looks into it. This is the section 47.
Agreement for sale.
Yes, my lord. And the learned judge, kindly have a look at the last page. First sees paragraph 4. It implies that there has been handing over of possession, creating fresh tenancy.
No, this is paragraph.
Paragraph 4, last line.
Achha.
Before the judgment.
Yes.
Because there has been, my lord, 2 more flories, he says, my lord, that he is now possessing on the basis of fresh tenancy.
What is the suit, the schedule of the
Yes, and it turns back.
or the decree?
Yes, my lord. The first.
Yes, page
the
31. Page
31.
31. Yes.
31. 1 Pakka west facing
Yes,
shop
yes.
on the ground floor. Degree, my lord, is at page 36. Lordship will find that, my lord, that it's a degree on that. And his 47 is it's a nullity because there is an agreement. And the court says that it's a fresh tenancy.
Yes, what do you say?
My lord, may I?
Don't say anything. Go on, Kafi. I'll pass my.
One thing for your lordship's kind
Yes.
consideration in facts, my lord. Judgment passed in the year of 2012. They filed the execution proceeding in the year of 2022 after 10 years. That is well within the time period. I cannot say anything about it. In between the same, my lord, in the year of 2014 and 2015, my lord, not only the agreement for sale has been executed, but also, my lord, in respect of the said agreement for sale, my lord, the payment has been made by the opposite parties, my lord, are received against that.
When
payment.
was the agreement made? 2014.
2014, my lord.
2014. Have you filed any specific performance suit?
He has admitted that he hasn't.
My lord, I have not filed any specific at that point of time, my lord. Subsequently, I have filed challenging the decree. Another suit was filed, my lord. That is subsequent, my lord. I have filed. But, my lord, in the year of 2014 and 2015, my lord, they have taken the money from me and they have issued the receipt against the same, my lord. That is on record, my lord. That is, I have that receipt, my lord.
Accepted. Then?
My lord, my
So what?
only.
So what? You know the fate of your matter. You have argued, your client is satisfied. Let me pass me.
My only humble submission, my lord, before your lordship, my lord, in case of any change of circumstances in respect of the suit property, my lord, decree becomes inexecutable in that respect, my
You have
lord.
done your level best. I can assure you that on that I am very serious. The present challenge arises at the behest of a decree holder in an eviction suit.
Lordship's kindly.
Yes. In connection with an order passed allowing the judgment debtor's application under section 47 of the Code of Civil Procedure. Push up next para. The eviction decree was passed in the year, heard learned counsel for the parties. Push up next para. The eviction decree was passed in the year 2012. Pushed up. In the year 2014, apparently an agreement for sale was entered into between the plaintiff landlord, between the decree holder landlord and the judgment debtor. Full stop. As per the judgment debtor stroke opposite party, upon such execution of the agreement for sale, the judgment debtor also paid full consideration amount to the decree holder, as such creating indefeasible rights in favor of the judgment debtor. Full stop. Next para. In the impugned order, the learned judge of the executing court allowed the application under section 47 on 2 grounds. First, that in view of the agreement entered into between the parties post-decree, the decree has become inexecutable Full stop. A further ground was that since further construction of stories have been made in the suit building subsequent to the passing of the decree, comma, the subject matter of the suit has altered. Full stop. Next para. Upon a careful consideration of the materials on record and the impugned order, comma, this court is of the opinion that both the grounds attributed to the to allowing the Section 47 application are not tenable in the eye of law. Full stop. First, comma, the the decretal property comprised of one pakka west-facing shop room on the ground floor of a then two-storied building. Full stop. Thus, comma, the eviction decree was confined to the decretal property, which is a shop room standing on the ground floor. Full stop. Hence, comma, construction of additional floors does not make a deviation or alteration in the subject of the tenancy. Full stop. Next para. Secondly, comma, an agreement for sale, comma, as clearly provided in the in section 54 of the Transfer Property Act, comma, does not by itself confer or create any title in favor of the agreement holder. Full stop. Next para. Even if the judgment debtor's contention of payment of money is correct, comma, in the absence of any valid registered sale deed, comma, no title has accrued in favor of the judgment debtor. Full stop. Next para. More importantly, comma, till date, no suit has been filed by the judgment debtor for specific performance of such purported agreement for sale dated sale of the year 2014. Full stop. Next para. Hence, comma, the agreement at best created an actionable claim in favor of the judgment debtor, which has not been exercised by the latter. Full stop. Next para. Thus, comma, under no stretch of imagination can it be said that either of the two grounds, as indicated above, rendered the eviction decree inexecutable. Full stop. Accordingly, CO 3132 of 2024 is allowed on contest, comma, thereby setting aside the impugned order being order number 52 dated July 3, 2024, passed in miscellaneous case number 12 of 2023, arising out of title execution case number 10 of 2022, within bracket, from title suit number 150 of 2008, bracket closed, passed by the learned Civil Judge Junior Division, Second Court at Uluberia, District, Howrah. Full stop. The executing court shall proceed with the execution case as expeditiously as possible. No rest to cost. Thank you. Thank you and sorry.
And my lord, so far the other revision application is concerned, that is relating to the another
Which one?
shop room. Immediate is 24. Both are the another shop room, my lord. The
Any
same
difference?
property, same and no difference, my lord, only in size. West facing. That is also west facing.
Both are west facing.
Both are west facing, my lord.
আচ্ছা একই অর্ডার কপি পেস্ট হবে আগেরটা যা হলো, শুধু দুটো তিনটে জিনিস চেঞ্জ হবে। সিও নাম্বারটা 3133 of 2024
and decree date is different.
Decree date
September 20. This one is present one is September 21, 2011.
আচ্ছা ডিক্রি ডেটটা হবে যেটা 2012 যেখানে আছে সেখানে 2011 হয়ে যাবে। আচ্ছা লাস্টে যেটা অর্ডারিং পোর্শনে যেটা করলাম, সিও নাম্বার সাচ এন্ড সাচ ইজ অ্যালাউড, সেটিং আছে সিভিল জাজ জুনিয়র ডিভিশন, সেকেন্ড কোর্ট, উলুবেরিয়া, হাওড়া, in miscellaneous case number 11 of 2023, execution case number 909 of 2022.
And it is mallet.
আর সুটটা হয়ে যাবে ব্র্যাকেটে টাইটেল সুট নাম্বার 64 of 2009. আচ্ছা আর ইমপিউন্ড অর্ডারটা সেটিং অ্যাসেট অর্ডার, the impugned order being order number 51 dated July 3, 2024. বাকি সব
Title is the same to it.
Thank you. হ্যাঁ হ্যাঁ সিরিয়াল করুন
Item number 12
দুটো
in the
দিন।
morning.
no no we'll now call serial you have missed your bus
My lord, it's very urgent, my lord, because of
Title
this reason that
execution 9 of
Passover matters we are calling we have
Title
also called Passover
execution
matters
হয়ে যাবে
is
9
also
of
passed over, I
2022.
think so, my lord.
then you have called it
My lord, item number 12.
Passover matter 12 to call হয়েছে নিশ্চয়ই তাহলে yes yes we have called
But,
we are proceeding serially after recess also call on the
এইটা
next
নতুন grateful man.
yes thank you
My lord, I am appearing on behalf of the petitioner, my lord. That is expeditious disposal, my disposal matter, my lord. I am the husband. Husband filed the matrimonial suits, my lord. There is a direction of the Honorable Justice, Honorable Sampa Sarkar, my lord. That
Yes.
I have been annexed. That is page 23. If your lordship wants go through that directions, expeditious disposal. That was the direction.
23.
Page 23. Order dated, my lord, 31/2024.
23 this is CO 3492
Yes, my lord. 3979 of 2023, sure. The 31/2024, that is order date.
Anirban Mukherjee versus Paulavi Mukherjee
Yes.
this CO number 3492
My lord, may I?
names are Anirban Mukherjee versus Paulavi Mukherjee
Yes, my lord. Pallavi Mukherjee back at Dev Roy.
yes CO number is 3492 item 36 এটা
PVL, we have not filed any CO, my lord.
3492 in the list also 3492
3979 of 2020.
no
that
no
is
some
CO
different
number.
matter you're confusing it is wrongly recorded it's appearing in the list as 3492
23, my lord, page 23.
page 23 is an affidavit
CO number, that is present CO 3492. And previous CO is 3979. That's order I am showing, my lord. To a
Oh.
lords. That is page 23.
page 23 of this
Yes, my lord.
let us check up page 23 of the revisional application is the affidavit page 23 Justice Shampa Sarkar's order is at
No, my lord. Then
page 34 anyway order date 30th of January
yes, my
24
lord. Yes, my lord. My lord, there is second page, that is page 24. There was a direction, my lord.
applications were direct what applications were pending
Three applications, my lord. Order 6, rule 17. Order on rule 10(2). As because, my lord, after the filing that suits, on inquiry, we came to know
adultery
that adultery.
and third application alimony
No, alimony is pending also. Alimony was pending also. And
what happened to those applications after this direction
nothing has been, only the alimony penalty has been heard out on 25/11/2024. Date was not fixed for any passing an order. They have to file and put up application, file and.
what about the order 6 rule 17 and 110
No hearing has been made, my lords. Nothing has been happened.
in view of the innocuous nature of the order proposed comma prior service of notice is not directed full stop the present application under Article 227 of the Constitution arises at the instance of the husband who is the plaintiff in a matrimonial suit, pushed up by an order dated July 30, 2024, comma, a coordinate bench had directed the pending applications, comma, including an application for amendment of the plaint and for addition of party as well as an interim interim alimony application to be disposed of within a period of 6 months from the
application that has been fixed upon 21/1 for passing the order.
From the next date fixed.
Yes, ma'am.
Full stop next para. However, comma, till date, alimony application has been decided.
All not decided, that has been heard out.
However, comma, till date, none of the said applications have been disposed of. Full stop next para. It is not understood as to why, despite the specific observation of the coordinate bench as long back as on January 30, 2024, that is almost a year back, comma, for expeditious hearing of the applications, comma, nothing has been done in that regard. Full stop. Be that as it may, comma, CO 3492 of 2024 is disposed of by directing the learned additional district judge, 13th court, the learned additional district 13th court at Alipur, district South 24 Parganas, positively to dispose of all pending applications in connection with matrimonial suit number 720/2020 of 2022 before it, mandatorily and peremptorily within February 28, 2025. Full stop. The present order shall be, a server copy of the present order shall be communicated by the learned advocate for the petitioner to the learned trial judge within a week from date. Full stop. Within a week from date. Full stop. The parties as well as all concerned shall act on the server copy of this order without insisting about prior production of a certified copy for the purpose of compliance. No rest to cost.
My lord, there was another decision on that particular order. If any mercantility is awarded by the learned court or a superior court in future, and husband complied with such direction, the said suit shall be disposal within the next 1 year. That is passing of the order of the that was that direction.
So next para, একটা লাইন অ্যাড করে দাও, নো অর্ডার্স টু কস্টের আগে। আর তার আগের সেন্টেন্সটা যেটা বললাম যে পার্টিস অ্যান্ড অল কনসার্ন শ্যাল অ্যাক্ট, তার আগে it is made clear that subject to the petitioner husband paying the interim order of alimony in time, comma.
No, my lord. If awarded, my lord, if awarded.
Interim alimony, comma, if awarded, comma, in time, comma, the learned trial judge shall dispose of the suit within 1 year from the date of disposal of the pending application. Next.
For the petitioner, my lord. And for expeditious disposal, my lord, the petitioner as a plaintiff, my lord, filed a suit under Section 6 of the Specific Relief Act for recovery of possession in 2021, May 2021, my lord.
What is the stage of the suit?
The stage of the suit is, my lord, that defendant has not filed their written statement and the written objection to the Order 39 Rule 1 and 2. An order of temporary injunction had been passed long back in 29 May 2021.
39(1)(2) is still pending.
It's pending, my lord.
প্রথম প্যারাগ্রাফটা একই হবে, in view of the innocuous nature of the order proposed. Next para, the plaintiff in a suit under Section 6 of the Specific Relief Act 1963 has preferred the present application, seeking early hearing of the pending injunction application.
And matter of the suit.
No, you have not paid for that, but in the suit. Full stop. Learned counsel for the petitioner also seeks a direction for early disposal of the suit itself. Full stop. Next para. Keeping in view the long pendency of the matter since the year 2021 and the implicit urgency in a proceeding under Section 6 of the Specific Relief Act, comma, this court is of the opinion that the purpose of justice would be subserved if the pending application and the suit are directed to be disposed of expeditiously. Full stop. Next para. Accordingly, CO number 3493 of 2024 is disposed of by requesting the learned civil judge junior division first court at Barasat, district North 24 Parganas, to dispose of the pending injunction application in connection with title suit number 325 of 2021 before it, as expeditiously as possible, comma, positively within 4 weeks from the date of communication of this order to the learned trial judge. Push up. Next para. Thereafter, comma, the learned trial judge shall dispose of the suit itself within 6 months from the date of disposal of the injunction application. Push up. Next para. The parties and all concerned shall act on the server copy of this order without insisting upon prior production of a certified copy for the purpose of compliance. No orders to call.
My lord, item number 38 for expeditious hearing, preemption suit of 2021, evidence of the OP, my lord. Presently, next day is fixed for evidence of opposite party.
In view of the innocuous nature of the prayer, no prior service of notice is directed. Push up. The present application under Article 227 of the Constitution of India has been filed at the behest of the preemptor.
Yes.
At the behest of the preemptor in a proceeding under Section 8 of the West Bengal Land Reforms Act. Push up. Next para. It is found from the records and from the submission of learned counsel for the petitioner that the suit is at the peremptory hearing stage and is, sorry, suit na. The proceeding is at the peremptory hearing stage and is pending since August 10, 2021. Pushed up. We also find from the records that several dates have been fixed without culmination of the preemption case. Full stop. Next para. Accordingly, CO 3511 of 2024 is disposed of by requesting the learned civil judge junior division at Raiganj district Uttar Dinajpur to dispose of miscellaneous case number 13 within 13 of 2021 within bracket preemption pending before it as expeditiously as possible, comma positively within September 30, 2025. Full stop. The petitioner shall communicate a server copy of this order and the learned trial judge shall act on such copy without insisting upon prior production of a certified copy of this order for the purpose of compliance. No orders to follow. Yes, 38. 38 কি হলো? 38 কি হলো? আগে হয়ে গেছে 39.
My lord, my application for expeditious disposal.
So many applications for expeditious.
My lord, miscellaneous
How will
appeal.
be strict?
My lord, miscellaneous appeal
Yes.
arising out of vacation of an order of an interim order in my order 39 rule for
Your
application.
39 rule 4 was allowed.
Allowed. They
Against
filed
that they
the
have
other
preferred.
side missed case.
You
my
want
lord,
the miscellaneous appeal to be
to be
decided.
disposed of, my lord, this pending since 2018.
Why? Any interlocutory revisional applications filed in the meantime?
My lord, one filed for expeditious order that was given to file to complete the hearing within 2 months.
That is
Nothing done, my lord, nothing.
Mr.
In the
Banerjee, any change of circumstances?
Small in the meantime, two of the respondents died. But they have been substituted, and now paper publication has been made. That has also
not done.
Oh, draft has been approved in September 24. Sorry.
But without completing them, how can I direct?
Now, my lord, vacating is pending since vacating the
Two parties have been vacated.
Two parties have been
So, we have to settle that first.
But to tell you, Lordship, Lord, I am a defendant appellant and the plaintiff is there. The other parties are co-defendants with me. And two of them are co-respondents with me. And it is the plaintiff who has got an ad interim order in the appeal, didn't get an order in the suit. And the plaintiff has set up a litigation on behalf of a union without having any right.
That is on the merits of the
There
case.
is, but yes, the frame I can understand. Frame is, it is precariously placed. Sometimes, my lords, hear out direct appeals to be heard out in the presence of the aggrieved defendant and the plaintiff. Kindly direct that. Because the other defendants, if they had any axe to grind, or their heirs, if they had any axe to
Paper
grind.
publication is regarding the pro forma respondent.
Pro forma respondent.
No, we will direct the appellate. That paper publication has happened in the suit as well as the appeal.
Only in the appeal.
Only in the appeal.
That paper publication has that paper publication draft has been filed, no publication. Your 7th of August 2024 order records. Appellant has filed a petition praying for extension. Today is the date filed for fixed for copy of draft. Appellant has filed draft copy of paper publication. Appellant was told to do that. Appellant means the defendant. Sorry, the plaintiff. Plaintiff.
In view of the innocuous nature of the usual order, first paragraph, the present application under Article 227 of the Constitution has arisen at the behest of the defendant number 4 in a suit for declaration injunction. What is this?
Yes.
Suit for declaration and consequential reliefs. Full stop. The defendant number 4 obtained an order under Order 39 Rule 4 of the Code of Civil Procedure in the suit, against which miscellaneous appeal number 11 of 2018 was preferred by the plaintiffs. Full stop. Next para. During pendency of the appeal, two parties died for which paper publication was directed and the draft for such publication was filed by the appellant, that is the opposite party number 1 series herein before the appellate court.
That draft has been approved by instructions are on 9th of September 24.
It is also submitted by senior counsel for the petitioner that the said draft has also been approved in the meantime. Full stop. Accordingly, since the miscellaneous appeal is pending since long, that is from the year 2018, ends of justice would be subserved in the event the appeal is directed to be decided early. Full stop. Hence, CO number 3519 of 2024 is disposed of, requesting the learned additional district judge, third court at Alipur, district South 24 Parganas, to ensure that the paper publication in respect of the deceased parties to miscellaneous appeal number 11 of 2018 pending before it is concluded as expeditiously as possible, and to dispose of the miscellaneous appeal itself also at an early date, positively within 4 months from the communication of this order to the learned appellate judge. Full stop, the parties as well as all concerned shall act on the server copy of this order without insisting upon prior production of a certified copy for the purpose of compliance, no arrest to cost.
I am on the other. This revision is against order of misappeal.
Yes.
Your petitioner
There is
a-
no caveat.
No caveat.
No caveat. Okay. This is for the first time appearing. Yes.
My lord, petitioner is a 72 years old lady.
Take the mic a bit. Yes.
Petitioner is 72 years old lady. She's a tenant of a one room. Try to fix or repair certain portion of the tile shade roof. The opposite parties are
this arises from an eviction suit filed against you.
no. Only the notice was given.
Notice of what?
Notice of eviction. Under section 664 West Bengal W.
So what is the appeal in connection with? So what is the suit for?
Suit for the only for to repair injunction against those.
Your suit.
My suit.
Acha.
I am the tenant plaintiff.
The suit is not maintainable. You have to approach the rent controller. Suit is not maintainable in law. If there is no eviction suit, then you cannot approach the civil court.
The notice has been served. They have not filed yet. The suit is of.
Go before the rent controller. The suit is not maintainable under section 9. Specific bar under the 97 Act. At least implicit bar. 2 provisions are there in the 97 Act for this. Probably 27 and some other.
My innocuous prayer, very little prayer, only to injunction against those persons who are in
Your
intervening.
injunction application was dismissed.
Not rejected by the Munsif, and after that, in appeal court, that was admitted, but the four of the appeals order that no reliable documents to show condition of the building was so poor. That is not a building. That is only.
What was the injunction sought? Injunction application was granted by the trial court.
No. That was refused only on one ground, that I am failed to appraise the court that I am a tenant in the question suit property.
You did not file any rent receipt.
I filed, but it was 1995, 1997. Old. Along with the eviction notice was given that the certain the owners have given me the eviction notice. Appeal court admit that I am a tenant, but hold that I have no document.
It has been remanded to the trial court.
Since then, it is pending. The matter was heard by the trial court on.
You are wanting the after remand the trial court to hear it out expeditiously. When was it remanded? Let us see.
10 May 2024.
But you have challenged that miscellaneous appeal order here. You have not paid for expeditious hearing.
Against that misappeal order.
The misappeal is in your favor. You have been given opportunity. Remand order. Remand order because
after showing all everything,
you must show prima facie documents to show that the condition of the building is. So you are given an opportunity. Instead of dismissing your application on that ground, it was remanded, giving you opportunity to produce evidence before the court below. What is the wrong in this order?
At the time of argument, we have filed the photographs of the existing building, damaged portion.
You know what to do. You should have asked for a local inspection at least. Damage photographs of building may be any building. How does the court ascertain that is the suit building?
A very poor lady not able to.
Poor lady is conducting the litigation. You have to make appropriate application. She'll become poorer if the suit is dismissed tomorrow.
Very
If the
bad
suit is not maintainable.
Very bad conditions.
Because of her age and her poverty, I'm not making any observation on that, but the suit is not maintainable. But I don't find any reason to interfere. The present challenge arises initially out of a suit filed by the petitioner claiming to be a tenant in respect of the property and seeking appropriate permanent injunction restraining the defendants from preventing or creating a hindrance to the repair work sought to be undertaken by the petitioner in respect of her tenanted premises. Push up next para. Initially, the learned trial judge, the application was dismissed. Dismissed the application primarily on the ground that the petitioner failed to substantiate her tenancy. Push up. The matter was taken up in appeal by the petitioner. Push up the learned appellate judge, although prima facie coming to the observation that the petitioner is a tenant in respect of the property, remanded the matter to the trial court to grant opportunity to the petitioner to produce reliable documents to show that the condition of the building was so poor that the same may adversely affect the safety of the petitioner. Full stop, next para. In the circumstances of the case, I do not find any irregularity of the order of the appellate court, since the petitioner was deficient in proving by cogent evidence or by local inspection that the condition of the building is such that it requires repair as sought by the petitioner. Full stop. Accordingly, there is no scope of interference in the revisional application. Full stop. Hence, CO 3541 of 2024 is dismissed without any order as to costs. Full stop. However, the learned trial judge is requested to dispose of the injunction application after remand as expeditiously as possible, preferably within 1 month from the date of communication of this order to the said court. No order as to cost. I've already said no order. Urgent certificate.
For the opposite party.
Yes.
I am praying for not today, Lordship.
Though I haven't filed caveat, but Lordship, I am appearing on behalf of opposite.
Give a copy to him.
Copy, sir.
An adjournment is sought on behalf of the petitioner. Full stop. The learned advocate, having instruction to appear for the opposite party, seeks a copy of the revisional application. Full stop. Accordingly, such copy is handed over by the learned advocate for the petitioner to his counterpart for the opposite party here and now. Full stop. On the prayer of the petitioner, let the matters stand adjourned for the day.
Item number 42.
None appears at the time of call. Adjourned for the day.
43, Your Lordship, I'm for the opposite party. Mr. Sanjeev Kumar Mal is appearing. I'm praying for a not today, Your Lordship.
You're for the petitioner. What do you say to this?
For a day's accommodation, I may not stand in the way, but
Day means 2 weeks because I take up only on Fridays, and next Friday there may be some difficulty, so it will go over till 31st. What is the matter about?
But as far as
Mr. Mal has not come to court.
No, Your Lordship, due to medical emergency, he has to leave the court.
not signing.
I'll record an order so that you can produce something in the court. An adjournment is sought on the ground of personal medical emergency of learned counsel for the opposite party. Push up accordingly, the matter is adjourned for the day. Please give your names. You also.
My lord, suit for eviction of a licensee, my lord, after the expiry of the lease period, my lord.
Plaintiff.
Yes. Now, my lord, ultimately, my lord, what happened, my lord, the written statement was filed beyond 90 days, my lord. Even thereafter, my lord, they filed an application under Order 8, Rule 9, my lord, incorporating certain things that was rejected. My lord, based on the written admission in the written statement, my lord, I filed an application under Order 12, Rule 6. Now, my lord, the order 8 rule 9 was rejected. Who sought to the tenant sought to, my lord, incorporate certain affirmance that was rejected. After that, my lord, the tenant filed an application under, my lord, with section 151. I filed an application order.
What? Section
151. So recalling of the order, my lord, that was rejecting, my lord, the order 8 rule 9. I filed an application order 12 rule 6. My application was rejected and order, section 151 as
Order
allowed.
12 rule 6 was based on that order 8 rule 9 new incorporation.
No, the original written statement. Now, my lord, this was rejected.
12.6 was rejected.
12.6 rejected. Because he admitted that the lease was expired on the month of October 2020. Now, the point, my lord, that was sought to be incorporated, that there was a verbal assurance on the part of the landlord, 45,000 rent, my lord, New Alipur, and, my lord, a huge area. The ground, my lord, made in the recalling application that he is ignorance of law, and that is why what steps to be taken at the right point of time, my lord, that was not unknown to him.
It was
Based
dismissed
on
expertly. That 8-9 application was dismissed expertly.
Yeah,
Due to default, dismissal
no,
default.
No, order, yes, no. Order 8 rule 9 was, order 8 rule 9 was rejected, my lord, not expertly. Not
on contest, on merits.
on contest. Yes.
On merits.
Yes.
Achha. So section 151 ground was ignorance of law.
Ignorance of law. Section 151 kindly sees, my lord.
That has been allowed. You are challenging that.
I am challenging that at my application rejecting, my lord, order 12 rule 6. They said, my lord, this is, and the point that was sought to be taken by the tenant, my lord, that no notice was given after the expiry of the lease. I said, my lord, that my respectful submission, my lord, on this code, my lord, that in terms of 111.
That will be decided in the suit. Order 12 rule 6, what was your ground? What is the admission?
My lord, admission,
show me that admission first. Because there are twofold challenge. One to order 12 rule 6, rejection, and the other
and
151.
allowing, my lord, section 151.
12.6, let us be satisfied first on that.
Let us page 34 of the written statement, of your lordship's brief, my lord, the
Yes,
written
yes,
statement.
Page 34. Which is the admission?
Yes, my lord.
Paragraph 5.
Paragraph 5, subparagraph 4.
4, yes.
That though the tenure of the said agreement was supposed to be expired on May 2020, however, owing to the reason of the outbreak of COVID-19 pandemic.
This is a Transfer Property Act lease.
Yes. So tenants, it's a sir,
not 97 Act.
No, 45,000 rent, my lord, beyond the limit.
Yeah.
45,000. So, my lord, this was
going to the
rejected.
reason, yes,
Yes,
expired
my lord,
on May
that is
20.
20. And my lord, the tenure of the said agreement was supposed to be expired on May 2020. However, owing to the reason of outbreak of COVID-19 pandemic, the defendant approached and requested the plaintiff to extend the tenure of the such and such for further period of 11 months, which the plaintiff verbally assured the defendant will renew, he will renew and or extend the said agreement for a further period of 11 months. Relying on such assurance of the plaintiff, the defendant continued to reside the suit property and continued to make the payment of license fees in terms of the agreement in the bank account of the plaintiff number Sanchez, which has been duly accepted by the tenant without any demur or protest. Now, my lord, I would like to show and my lord, 1 to 4, the order 12 rule 6 application. Page 51, my lord. May I request your lordship, my lord, page 51. It starts from 45, but 45 is not relevant. 51, my lord. No. Kindly seize, my lord. It's 49. The defendant, after being summoned, entered appearance in the suit, and in the meantime, defendant filed written statement. In the said written statement, the defendant admitted the case of the plaintiff. Page 49, paragraph 3, subclause 1, Roman 1.
Yes.
My ground, my lord, is restricted to paragraph, that is when paragraph 5.
You said he is a leave-in licensee.
So
you seek eviction on that ground. You
Right.
say he has admitted he is a licensee after expiry. So you will get that eviction.
Number one, and my lord, and my lord, the first of all, and second, my lord, that he sought to take up a point, my lord, that after the expiry of the lease, when he was allowed to continue, my lord, he was entitled to have a notice. My lord, according to my understanding, my lord, he was a tenant at sufferance in terms of
license is not entitled to notice.
No notice. So, my lord, today, my lord, and my lord, the
What about
order.
section 151?
151, my lord, kindly sees.
Yes.
Recalling.
By the
paragraph
same
4.
Order, by the same order. Yes.
This was allowed.
Understood. Which page?
Page pillar 69, paragraph 4.
Yes, what is the ground?
When your petitioner state that he is almost ignorance of law your petitioner does not know in which stage what is to be done, which I have submitted, my lord, written or and taken step or not in law. Your petitioner came on that though mistake of the learned advocate did not mention the reason in the case of not incorporating the facts in the original written statement.
What is the please show me the original order rejecting that order 9, order 8 rule 9
on page 68. তাই না?
Additionally add code.
Record is fixed for hearing. My lord got it.
Yeah.
Application to order 8 rule 9.
Yes, let us see how it was allowed. Section 1.
Now the impugned order, my lord.
Yeah.
এইটাই তো এইটাই তো
হ্যাঁ এটা ইমপ্লিমেন্ট নোটিস What sort of interim order are you expecting in this revisional application?
My suit is my lord, at the evidence stage, my lord. So my lord, there court is not granting any adjournment. Next date জানিস কবে?
So stay of your suit.
Stay of my
Good. The present revisional application arises from a suit for eviction filed by the plaintiff's petitioners on the ground that the defendant,
the defendant
on the ground
Yes.
that the defendant is a licensee in respect of the premises. Push up next para. In paragraph number 5 within bracket small iv of the written statement, comma, the defendant admitted that he is a licensee in respect of the premises. Full stop. Although the defendant has taken a plea that no notice of eviction was served on him, comma, learned counsel appearing for the petitioner has made out a strong prima facie case as to such license not being necessary in an eviction suit of a licensee, and a prima facie case has also been made out to the effect that in view of the admission contained in paragraph 5 within bracket iv of the written statement, comma, the plaintiffs stroke petitioners were entitled to a judgment on admission under order 12 rule 6 of the code of civil procedure. Push up, however, comma, by the impugned order, comma, the application under the said provision made by the plaintiff stroke petitioners was dismissed. Push up next para. Secondly, comma, although by a previous order, comma, a previous order dated May 7, 2024, comma, the defendant stroke opposite party apostrophe s application under order 8 rule 9 of the code of civil procedure was rejected on several grounds on merits, comma, by the second portion of the impugned order herein, comma, an application filed by the defendant petitioner defendant opposite party subsequently under section 151 of the code of civil procedure for recall of such order was allowed, comma, thereby virtually the trial court sitting in judgment over its own previous order, which is not permissible in law. Full stop. Next para. The revisional application is required to be heard on the above questions. Full stop. Accordingly, the petitioner shall serve a copy of CO number 3577 of 2024 on the opposite party, indicating that the matter shall be listed before the appropriate bench for contested hearing in the monthly list of February 2025, subject to the convenience of the said bench. Full stop. The petitioner shall file an affidavit of service to that effect on the next date of hearing. Full stop. There shall be stay of all further proceedings in title suit number 283 of 2022, pending before the learned civil judge, senior division 10th court at Alipur district, South 24 Parganas, till when? Till disposal. Because your suit, that's right.
No, till February.
Till February 28, 2025, or until further order, whichever is early. This will give you a handle to mention it for extension, and you can get it heard.
Thank you.
Thank you.
Item number 45.
45 or I will for the petitioner. Well, a suit for eviction and
One second.
filed in 2003.
Suit for eviction 2003.
My lord,
Yes.
the earlier 7-2 application was decided on merits, my lord. The original defendant died, my lord. The legal heir substitute, they again filed another 7-2, my lord.
Not maintainable.
My lord, raising self-same issue, my lord. My lord, this honorable directed the learned court below to decide that 7-2, this was in July 2023, within 1 month, and my lord, the suit to be disposed of within 6 months thereafter. But nothing has been done. Again, I approached this honorable court. Again, this honorable shown his displeasure and my lord recorded and then directed that as a last chance, the learned court below is directed to dispose of the application within 1 month and the suit within 6 months thereafter. Still now, my lord, till today, nothing has been done. Neither the application has been decided. My lord will kindly see the last order passed by this honorable court at page, my lord, 63. The next page is, my lord, certified copy of the order of, my
In
lord,
view of the innocuous nature of the order proposed to be passed, no prior service of notice on the opposite parties is deemed necessary. Full stop. Next para. The present application under Article 227 of the Constitution of India arises out of an eviction suit filed by the plaintiff stroke petitioners. Full stop. In the said suit, the original defendant had filed an application under Section 7 within bracket 2 of the West Bengal Premises Tenancy Act 1997, which had been disposed of. Full stop. Subsequently, on the demise of the original defendant, his or her, the original defendant,
my lord, his.
don't remember.
My lord, his.
His heirs and legal representatives were substituted as defendants in the suit. Such substituted defendants filed a fresh application under Section 7 within bracket 2 of the 1997 Act, which has been kept pending inordinately by the learned trial judge. Next para. From the records, I find that initially by an order dated July 24, 2023, passed in CO 654 of 2022, a coordinate bench of this court had directed the learned trial judge to dispose of the pending application within a month from the next date fixed, and thereafter to make endeavor to proceed with the suit and dispose of the same within a period of 6 months after disposal of the application, without granting unnecessary adjournments to either of the parties. Next para. Again, in view of the said order of the coordinate bench having not been complied with, an order was passed on March 15, 2024 by the learned single judge in a different revisional application bearing CO 4528 of 2023, whereby it was recorded that the court gives one last opportunity to the learned civil judge, junior division, closed, 6th court at Alipur, to dispose of the application under Section 7 within 2 of the 1997 Act within a month from the next date fixed, and thereafter to dispose of the suit preferably within 6 months. Next para. However, an utterly lackadaisical approach on the part of the learned trial judge is apparent, since till date the neither the application nor the suit has been disposed of. Next para. CO 3581 of 2024 is accordingly disposed of by directing the learned civil judge, junior division, 6th court at Alipur district, South 24 Parganas, to dispose of, peremptorily and mandatorily, the pending application under Section 7 within bracket 2 of the West Bengal Premises Tenancy Act 1997, filed in connection with case number RC 98 of 2003, pending before the said court within 1 month from the date of communication of this order to the said court, by acting on the server copy of this order. Next para. The suit itself shall be disposed of within 6 months thereafter positively. Next para. A copy of this order be communicated by the learned advocate, communicated by the petitioners to the concerned court for early implementation of the same. A further copy, a further server copy shall be served. A further server copy of this order shall be served on the learned district judge, South 24 Parganas, to ensure that the orders of this court are complied with by the concerned judge, that is the 6th Court of Civil Judge, Junior Division at Alipur. full stop, next para, upon disposal of the said application, comma, a report shall be filed with the registry of this court regarding such compliance, comma, which shall be placed by the Registrar General before this court for passing orders if necessary.
Extremely good.
আরেকটা লাইন অ্যাড করে দিতে হবে, a copy of this order be forwarded by the office to the learned Registrar General of this court. Next.
Lordship, I am appearing on behalf of the advocate and record for the petitioners.
Hmm.
Since he is unwell, I pray for not today, Lordship. He's not.
On the prayer of the petitioner, the matter is adjourned for the day.
Under my petition, let's suit for eviction of licensee and for money.
Money means arrears.
Arrears.
Licensee, what arrears? License fee.
License fees. After during filing, I had also filed an application under Order 39 Rule 1 and 2 and also under Order 39 Rule 10. 1 and 2 has been heard, injunction has been given. After that, what the defendants did, they had filed an Order 7 Rule 11. That has been heard, that is for orders. The order is to be pronounced tomorrow. What I'm praying that tomorrow let the Order 39 Rule 10 also be heard. The affidavits are complete. On the last occasion, my lord, there is also the order
It will be too short a time for the other side to get prepared. My lord, you can't. It will be too short a time for your opposite party to get prepared on that order one.
But they have already filed the opposition. Kindly seize the
So
order.
even if they have filed the opposition, they'll get the order this evening, and their advocate has to prepare himself for the next morning. No.
Very well.
We'll do that. I'll do this. I'll direct that order 1 Rule 10 to be disposed of within a fortnight thereafter.
Very grateful.
In view of the innocuous nature of the prayer, no prior service of notice is directed. Push up. The plaintiff in a suit for eviction of licensee and consequential reliefs, as well as for arrears of license fees, is the petitioner before this court. Push up. It is submitted by learned counsel for the petitioner that a previous application for injunction filed by the petitioner was disposed of by the learned trial judge. Pushed up. With regard to a subsequent application under Order 1 Rule 10 of the Code of Civil Procedure filed by
Order 39 Rule 10.
Oh, Order 39 Rule
Order
10.
13.
Under Order 39 Rule 10 of the Code of Civil Procedure, comma, the same was heard and is awaiting orders to be passed tomorrow, which is the next date fixed. Pushed up.
My lord, I'm sorry. I
Oh,
did not
sorry.
Order 7 Rule 11 and
Right, sorry. এই সেন্টেন্সটা কি বললাম মেঘনা? লাস্ট সেন্টেন্সটা এইখান থেকে কেটে দিয়ে আমি আবার করে করব। Another application under Order 7 Rule 11 of the Code of Civil Procedure, comma, filed by the defendant number 1 by the defendant stroke opposite party number 1 has been heard by the learned trial judge and reserved for judgment and is awaiting orders to be passed tomorrow, comma, which is the next date fixed in the trial court. Push up next para. However, comma, the pending application under Order 39 Rule 10 of the Code of Civil Procedure is yet to be disposed of. Push up. It is submitted by learned counsel for the petitioner that the Order 39 Rule 10 application is otherwise ready for hearing since pleadings have been exchanged between the parties and may be directed to be disposed of expeditiously. Because of next para, accordingly, CO 3601 of 2024 is disposed of by requesting the learned commercial court, North 24 Parganas at Rajarhat, to dispose of the pending application under Order 7 Rule 10 of the Code of Civil Procedure tomorrow, which is the next date fixed. Pushed up. The learned trial judge is also requested to take up for hearing the application, the pending application under Order 39 Rule 10 of the Code of Civil Procedure filed in connection with TS within bracket COM 93 of 2024 tomorrow itself, and to dispose it of as expeditiously as possible, comma, positively within a fortnight from date. Full stop. The parties as well as the learned trial judge shall act on the communication of the learned advocate for the petitioner, coupled with a server copy of this order without insisting upon production of a certificate.
Grateful.
এই অর্ডারটা একটু তাড়াতাড়ি করে দিন। এটা আগের দিকে করে দিয়ে স্যার যাতে সার্ভারে হয়ে যায় তাহলে কালকের মধ্যে করতে পারবো না। এমনিতেই তো হয়ে যাবে।
My lord, petitioner is a defendant in a suit for declaration injunction, my lord. There, my lord, the local cultural organization, my lord.
Local
cultural organization. No, my lord, it was a contention of, my lord, the plaintiff.
Cultural organization with muscles or without muscles? Yes.
No, my lord, now the contention of the plaintiff is, my lord, they are the owner, my lord, in respect of suit property, my lord, pursuant to a deed dated for the year 1971.
Deed means transfer deed.
A deed of sale.
Sale.
Deed of sale. Now, my lord, it was our contention, my lord, specifically, my lord, contained in the written statement also, my lord, that we are the owners in view of a deed of gift prior to that, my lord, that is 1960. On the evidence, my lord, of
the suit was for, what did you say?
Declaration injunction.
They seek a declaration for their title.
For their
on the basis of?
On the basis of, my lord, their sale deed. That is of 1971.
Oh, 71 is their sale deed. And your claim?
1960. That is a registered gift deed.
Then?
Now, my lord, from the same person. Now, my lord, deed of gift, my lord, could not be produced, my lord. Only a copy of the gift was produced, my lord. It is make X for identification. Now, my lord, evident, my lord, it is admitted position, my lord. The evidence was complete. Now, my lord, when it was fixed for argument, my lord, we have filed a petition, my lord, to call for the volume in respect of particular deed so that it can be tallied or, my lord, verified.
Satisfied the court regarding why secondary evidence should be.
No, my lord, that occasion, my lord, was not arising, my lord, because of the fact that the court proceeded from the beginning, my lord. That is apparent from the order itself, my lord. It's a dilatory tactics and negligence on your part. We are not.
You had to file a proper application for adducing that as secondary evidence.
No, I have prayed for, my lord, calling for volume in respect of particular deed to be marked as exhibit, my lord, so that it can be compared.
Allowed unless you cannot produce for some reason. If you cannot, that would also be corroborative evidence. That has been rejected.
That has been rejected. My lord, my contention will go, my lord. Had, my lord, this deed been, my lord,
why rejected? What is the reasoning given?
My lord, order dated 9 July 2024. The examination chief was completed on 1st February, 1st December 2022. Now in the year 2024, when the suit has been fixed for argument, the defendant realized a particular exhibit. Now from these record, the negligence on the part of
what stage did you come up?
Well, argument.
Then
I filed 2 petitions, my lord, for taken off. Taken off was allowed, my lord, with 7.
So this was at a very belated stage.
My lord, maybe, my lord, it's a, my lord,
dilated.
No, my lord, let's kindly fix the matter. Let's kindly fix the shoot, disposal of the shoot. For 3 months, within 3 months, within 2 months, my lord, no issue, my lord. But, my lord, this particular deed, my lord, which is prior deed, my lord, I have specifically pleaded in my, my written statement that I have given, my lord, particular deed number. And, my lord, interestingly,
examination in chief of DW1 was completed on 1st of December 2022. That is the finding.
Yes.
And you have filed this petition after 2 years, after almost 2 years, to 2024 for marking exhibit.
Other, my lord, evidences were going on, my lord. Immediately after completion, my lord, when it was fixed for argument, I have filed this petition.
Let me see the petition.
My lord, certified copy, my lord, it was along with certified copy. My lord, just it was attached with the certified copy of the order, my lord. I have given, my lord, the type copy. Dorkhasto secretary, my lord, there, my lord, the secretary, my lord, they don't, my lord, keep all these documents, my lord, about, my lord, 65 years back deed, my lord.
The present application under Article 227 of the Constitution of India arises out of a suit for declaration of title and injunction filed by the defendants on the basis of a title deed of 1971, whereas the defendants to petitioners herein claim their title on the basis of a purported deed of gift of the year 1960, whose next para, during evidence, however, the petitioners could not produce the original of the said gift deed, although a photocopy of the same was sought to be produced. Whose next para, after learned counsel for the petitioner submits that immediately after the conclusion of the evidence of all the witnesses, comma, at the juncture when the arguments were to commence, comma, the defendant stroke petitioners filed an application for calling for the concerned volume from the registration office to prove the execution of the gift deed. Such application was turned down by the impugned order primarily on the premise that the petitioners were negligent, comma, since the evidence of DW1 was concluded long back in the year 2022. The question which is to be decided is whether the relevant date would be the conclusion of the evidence of DW1, since the petitioners claim that the evidence of other witnesses continued long thereafter, and the application which was rejected was filed almost immediately after conclusion of the evidence. Next para. Accordingly, the petitioner shall serve copies of CO number 3621 of 2024 on the opposite parties, on the opposite parties, indicating that the application shall be listed before the appropriate bench having determination for contested hearing in the monthly list of February 2025, subject to the convenience of the said bench. Next para. There shall be stay of all further proceedings in title suit number 101 of 2023 pending before the learned civil judge, junior division at Holdia, district Purbo Medinipur till February 28, 2025 or until further order, whichever is ordered. On the prayer of the year for the petitioner. On the prayer of the petitioner, the matter is adjourned for the day. None appears for the parties, adjourned for the day.
I am for the plaintiff petitioner, my lord. I am praying for expeditious disposal of ejectment suit, which is pending since 2022.
2022.
The plaintiff is a senior citizen, septuagenarian citizen, my lord.
Septua or octa?
Septua.
What is the stage of the suit?
Stage peremptory hearing, my lord.
Peremptory hearing?
It's
proceeding quite fast. We cannot blame that 2022 eviction suit. Peremptory hearing going on is a very, very early hearing.
Learned court below is fixing inordinately long dates for hearing, my lord. 3 months, 4 months.
You have to appreciate in every matter these directions cannot be given. 2022 suit is on the peremptory board. That's quite fast. Quite fast.
Issue is framed on the last.
Lord the trial judge for doing this.
My lord, issue is framed on the last date, my lord. Otherwise.
No. I'll record my confidence that the trial court will finish within time, but not give a specific timeline.
My lord, kindly give us.
And I'll record that it is laudable that the eviction suit of 2022 is on the peremptory board so soon. No.
Kindly fixes a date.
The plaintiff in an eviction suit has filed the present application for expeditious disposal of such eviction suit. I find from the records that the ejectment suit number 38 of 2022 was filed by the plaintiff in the year 2022 and is already on the peremptory board. I do not find any latches on the part of the learned trial judge, since an eviction suit of 2022 being on the peremptory board by the end of the year 2024 speaks volumes about the diligence of the learned trial judge, keeping in view the excessive pressure under which our civil courts function. Next para. Be that as it may, keeping in view that the petitioner is a septuagenarian, this court expresses full confidence that the learned trial judge shall dispose of the suit at the earliest, preferably within June 30, 2025. June 30, 20.
Much obliged.
No address to cost. A dispose of ki bolechi kotha? CO number such and such dispose of bolechi. No address to cost. Thank you.
53, my lord, I'm praying for not today. On behalf of petitioner.
On the prayer of the petitioner, the matter is adjourned for the day. Please give a name, ma'am. Yes, next.
Lord, I appear for the petitioner, my lord.
Petition.
Lord, in view of the old age of the petitioner, my lord, I have approached your lordship, my lord. The petitioner is 92 years old, my lord. My lord, he has won the case in both the courts below. Second appeal preferred, my lord. conditional order of stay was passed, not complied, no reimposition application, my lord. My lord, we levied the decree to execution. Due to stiff resistance, my lord, thereafter we filed an application for police help. But that application is lying stalled, my lord, for so many days, my lord. One after one, my lord, section 47 application was taken out by the opposite party, my lord, that has been rejected. Lord, I am seeking for, there was a couple of directions, my lord, by this honorable court for the expeditious disposal of my miss case, my lord. I'm seeking
Miss case is under what provision? 108.
Order 21, yes, my order 21, rule 97, read with rule 208 of the civil rules, my lord. Lord,
When was it filed? 22.
My lord,
Miss case of 22.
miss case of 22, my lord. My lord, decreed in 2017, my lord.
In view of the innocuous nature of the order proposed, no prior service of notice is directed on the opposite party. Full stop. The plight of the petitioner (92) you said.
My lord, 92.
The plight of the petitioner evokes empathy in the mind of the court. Full stop. The petitioner, comma, a nonagenarian, comma, filed an eviction suit in the year 2012, which was decreed on December 20, 2017. Full stop. Thereafter, execution was levied. Full stop. The defendant stroke opposite party preferred
Title appeal.
a title appeal, where having failed to succeed, comma, the defendant took out a second appeal before this court. Full stop. The second appeal was admitted. The second appeal was admitted and an interim stay was granted, comma, however, comma, on condition of payment of occupation charges by the defendant stroke opposite party. Full stop. Learned counsel for the petitioner submits that the opposite party did not comply with such payments, with such condition, due to which, comma, in terms of the order of this court, comma, the execution was sought to be proceeded with by the petitioner. Full stop. However, comma, the woes, WOES, of the petitioner started thereafter. Full stop. The opposite party stroke judgment debtor, comma, by various devices, comma, sought to stall the execution. Full stop. An application under section 47 of the Code of Civil Procedure was also filed and the same was dismissed. Full stop. Even thereafter, comma, the present miscellaneous case bearing miscellaneous case number 48 of 2022 has been kept pending since the year 2022 for no justifiable reasons. Full stop. The said miscellaneous case was has been filed under Order 21, Rule 97 of the Code of Civil Procedure, comma, read with Rule 208 of the Civil Rules and Orders framed by this court for implementation of the decree in connection with the execution case. Full stop. Next para. Accordingly, CO 3665 of 2024 is disposed of by there is no Order 21 Rule 101 or anything like that pending.
My lord, there is by the sister of the opposite party.
Then
that is lying pending, my lord. I have
Then-
stated, my lord. My lord, what happened, my lord? The sister of the opposite party instituted a suit, my lord. We filed an application order 7 rule 11 that was rejected. My lord, challenging the same, we preferred a revisional application, my lord. My lord, upon staying of the all further proceedings of that suit, my lord, this application has been taken out by the sister of the
so
opposite party.
Order 21 Rule 101 is pending at the behest of somebody.
At the, my lord.
So that has to be decided first. What is the number of that?
My lord, 64.
You should have said that at the outset.
My lord, that has been.
I was going to pass a very wrong order. Statute says that if such an application is pending, we cannot execute.
My lord, in fact, that is all in furtherance of their electric tactics, my lord, one after another. My lord, Section 10 application was initially taken out.
What is the missus number? Where have you disclosed?
Yes, my lord.
Thank God I asked.
21.
Thank God I asked.
Miss case 64 of 2024, my lord.
Last sentence, accordingly, CO number কেটে দাও। No, this is a different suit. Para 21 speaks of a different suit, not an Order 21 Rule 101 application.
Yes, Order 21, Rule 99.
Where is that?
101, Para 21, page 12, my lord.
Oh, acha, acha. That miscase has to be heard out first. The next para, at this juncture, comma, on the query of court, comma, learned counsel for the petitioner points out that miscellaneous case number 64 of 2024 is also pending under Order 21 Rules 99 to 101 of the Code of Civil Procedure at the behest of a third party, comma, judgment register, who the petitioner claims to be the sister of the judgment debtor opposite party. Push up next para. The established law is that unless a challenge under Order 21 Rules 99 and or 101 of the code are disposed of, comma, the execution case cannot be proceeded with. Full stop. Accordingly, CO 3665 of 2024 is disposed of by requesting the learned civil judge, senior division, second court at Barasat, district South North 24 Parganas, to dispose of miscellaneous case number 64 of 2024 pending before it, and along with any other interlocutory applications which may be pending in connection with title execution case number 12 of 2018 as expeditiously as possible. Full stop. It is expected that miscellaneous case number 64 of 2024 shall positively be disposed of within 2 months from the date of communication of this order to the executing court. Full stop. Next para. Immediately thereafter, comma, the executing court shall proceed with the and dispose of miscellaneous case number 48 of 2022 filed by the present petitioner, comma, preferably within a fortnight thereafter. No address to cause urgency.
This is for expeditious disposal of a suit of 2010, my lord. It's for declaration and injunction, my lord. I am the defendant in the suit. I've been added, rather added as a defendant in the suit, my lord.
What is the stage of the suit?
The suit was filed in 2000, so filed in 2010, no summons initially.
Any application pending?
Only an Order 7 Rule 11 application pending, my lord. In fact, there was a direction by this honorable court to dispose of the same in 3 months. That direction is at page 37.
What about the injunction application and the other applications?
Nothing else is pending. Only one Order 7 Rule 11 application is pending, not by me, by the KMC. Without a statutory notice, the suit was filed against KMC as one of the defendants. That is why that is pending.
So we can direct that to be decided. Suit if I give say 6 months, and if the Order 7 Rule 11 is allowed, it will be less than 6 months. We'll direct that to be decided.
Right.
In view of the innocuous nature of
the only thing, my page 37, that was already directed once.
711 to be disposed.
My lord. In fact, Order 1 Rule 10 and 711. Order 1 Rule 10 has been decided on 1st March 2024. 711 is still pending.
Another single bench, another coordinate bench had directed.
My lord.
Very well. In view of the innocuous nature of the order proposed to be passed, no prior service of notice on the opposite parties is directed. So next para. The present application under Article 227 of the Constitution arises out of a declaratory suit filed by the opposite party number 1, where the petitioner is the petitioners are the added defendants. Full stop. The suit, comma, of the year 2010 is pending since long. Full stop. It is submitted that despite a previous direction, comma, although an Order 1 Rule 10 application, although an application under Order 1 Rule 10 of the Code of Civil Procedure has already been disposed of, comma, there is still a pending application under Order 7 Rule 11 of the Code of Civil Procedure filed by defendant opposite party number 3, the Kolkata Municipal Corporation. Push up next para. In keeping in view the previous order of the coordinate bench to dispose of the same expeditiously, as well as in view of the long pendency of the application, comma, CO number 3669 of 2024 is disposed of by directing the learned civil judge, junior division, 5th court at Alipur, district South 24 Parganas, to positively dispose of the pending application under Order 7 Rule 11 of the Code of Civil Procedure at the behest of the defendant opposite party number 3, filed in connection with title suit number 224 of 2010, as expeditiously as possible, comma, positively within 4 weeks from the date of communication of this order to the learned trial judge. No address to cost.
Deeply.
Not today. Sir, petitioner. The petitioner prays for an adjournment. Let the matter stand adjourned for the day. Same order.
Lordship, my opinion on behalf of the petitioner is a prayer for expeditious disposal of the petition of suit. Eviction, injunction, and means profit against the defendant.
Use the microphone.
It's a expeditious disposal of a.
Can't hear you. The microphone is on.
It's an expeditious disposal for eviction of a suit which is pending for 2021.
What is the stage of the suit? Eviction suit?
Eviction suit.
What is the stage?
The stage is for hearing. Expeditious hearing stage.
What expeditious hearing?
The hearing stage or SRAR hearing stage. Appearance.
No application pending?
No application pending, Lordship.
No section 7 application?
No, Lordship.
2021 is not very old. Why should you direct the expeditious hearing at this stage?
The petitioners
Much older suits pending. Why should this get a precedence in the queue?
They are the tenant. We are the landlord.
That does not give you a right. There are hundreds of matters pending eviction suits at the BS of 10, which are much older than this.
Lordship, come to page number 48. Lordship, there is in para 5. There is after a long gap of 8 months.
Page 48.
A4. Page 4, para 5. The urgent need of hearing of the suit next date is fixed on 5/12.
Para 5 years.
After a long gap of 8 months, as praying for in order of expeditious hearing on title suit pending in the for providing justice of the.
Very well. The grievance of the in view of the innocuous pratham paragraph the same. Second paragraph. The grievance of the plaintiffs to petitioners in an eviction suit is that the suit has been kept pending since long. Full stop. Next para. Although the suit was filed in the year 2021 and much older suits are pending in the concerned court, the plaintiffs submit that excessively long dates are being fixed for hearing of the suit. Full stop. Next para. In fact, the last date was fixed on December 5, 2024 after a long gap of 8 months. Full stop. Next para. Keeping in view the implicit urgency in an eviction suit, CO 3698 of 2024 is disposed of with a request to the learned civil judge, Junior Division, First Court at Barasat, District North 24 Parganas, to dispose of title suit number 802 of 2021 pending before it as expeditiously as possible, positively by June 30 to 2026. No rest to cost.
Sir, Partho Pratim Roy is appearing for the petitioner. He is engaged in another courtroom.
The prayer of the petitioner, the matter is adjourned for the day.
Very well. Lordship, my opinion on behalf of the petitioners, it's a matter for eviction, expeditious disposal.
Which year?
Year of 2021.
Long gap of para 5?
A long gap of 8. Same.
Similar
type but different tenant.
যে আগের অর্ডারটা দিলাম ওকে আগেরটা ওনাকে যেটা দিলাম
for next matter also, Lordship.
PO number 3700 একই অর্ডার কপি পেস্ট হবে CO number 3700 of 2024 আর সেম কোড
Yes,
আর টাইটেল সুটের নাম্বারটা হবে 767 of 2021. Here also there was a previous order.
Yes, Lordship.
এই দুটো চেঞ্জ হবে
For next matter also.
Next matter, let us call on the next matter. Here also same facts. Circumstances, previous order of court and all. 8 months, long gap, 5. Para 5.
Para 5.
দাও এটা আগেরটা এটা 62টা
My lord, I'm appearing for the petition. I'm praying
No,
for.
no, 1 second. 62. His matter was 61 and 62.
61 and 62.
1 second. 61 আমি অর্ডারটা করলাম তো You have total 3 matters. না আগেরটার মতো বললাম 62টা 61টা আচ্ছা 62টাও তো অর্ডার হবে সেটা তো আলাদা স্যুট হবে 62 ফাইলটা দাও সেম ম্যাটার মানে স্যুট ফুট গুলো তো আলাদা হবে আপনাকে কিচ্ছু করতে হবে না আপনি শুধু যা কল করছেন তার ফাইলটা তুলে দেবেন সেম ম্যাটার কিনা আমি চিন্তা করব আমি কি বলছি আপনাকে মাথা ঘামাতে হবে না। যে ম্যাটার কল করবেন তার ফাইলটা দেবেন 62 তেও সেম কপি পেস্ট হবে সিও নাম্বারটা 3704 অফ 2024 আর এভিকশন স্যুটটার নাম্বারটা হচ্ছে টাইটেল স্যুট নাম্বার 801 অফ 2021 বাকি সব এক
স্লিপটা দিন
হিয়ার অলসো দেয়ার ওয়াজ এ প্রিভিয়াস অর্ডার ইয়েস নিন আপনি যা কল করবেন সেই ফাইল দেবেন আপনি চোখ বন্ধ করে থাকবেন চোখ বন্ধ কানটা খোলা রাখবেন দিন 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 63 দিন yes what is the matter
My lord, I'm appearing for the petition. I'm praying for a not to
you have
demand.
to start the matter otherwise dismiss for default start the matter what is the matter about
My lord, this is my civil revision application.
May I, not one thing, my lord. Lord, Mr. Chottoraj is, my lord, appearing.
you also have to start contesting the matter
I am not in the.
no she has to start the matter yes what is the matter
My lord, this is my civil revision application, my lord, which is against the order dated 29th August 2024, wherein my written statement has not been accepted by the court below, my lord.
what is the wrong in that
My lord, that my written statement was filed beyond a period of 120 days as prescribed under Order 7, Rule 1, my lord.
so rightly done what was your excuse
My lord, I was never served with the copy of the plaint, my lord, and with a very bona fide interest on various occasions by.
this is not a commercial suit
No, my lord.
yes what is your answer to this
Not in the brief, my lord. Lord, Mr. Chottoraj is, my lord.
Mr.
Rajmohan Chottoraj is appearing for the, my lord.
you are in the chamber of Mr. Chottoraj you are not at all connected with him
But I was asked to, my lord, take an adjournment because he is, my lord, seriously ill and, my lord, hospitalized, my lord. I was asked to take an adjournment.
Very wrong. Since an adjournment is sought for on behalf of the opposite party, let the matter stand adjourned for the day.
Obliged, my lord.
Well argued.
Thank
Yes, next matter.
My application.
Yes, sir. What is your matter?
This
No
is-
caveat.
No caveat. This is a matter is expedited hearing. You know.
Yes. You আগেরটা ওনার নামটা নিন sorry expeditious hearing
Matter related to owner first and this is suit for declaration.
suit for declaration
For declaration.
oh today there is 3:30 I had forgotten suit for declaration you are the plaintiff
I have the plenty petitioner.
right
Suit for 2017.
2017 what is the stage of the suit
But nothing. There is one interlocutory application is there. Order 1, Rule 10. Is 10 from 17 it is carry on. Date.
only one interlocutory application is
Only
pending
one interlocutory by the defendant. And should
this
be.
is the 9th court of civil judge senior division
Yes,
Alipur
Alipur.
in view of the innocuous nature of the order proposed to be passed no prior service of notice on the opposite parties is directed it is submitted by learned counsel for the petitioner that the suit as well as a connected application under order 1 rule 10 of the code of civil procedure is pending inordinately first of next para since the suit was filed in the year 2017 comma there is substance in the contention of the petitioners first of accordingly CO number 3714 of 2024 is disposed of with a request to the learned civil judge senior division 9th court at Alipur district south 24 Parganas to dispose of title suit number 423 of 2017 along with connected applications if any comma as expeditiously as possible full stop it is expected that the pending application
Next
within-
24th day.
Pardon?
24th January the next date for an application.
Within bracket S application within bracket S shall positively be disposed of by January 31 2025 and thereafter the suit shall be disposed of within December 31 2025
Under compelling circumstance in the first step, I tried to mention the matter item number 13, Lordship, application for expeditious hearing, Lordship.
no what compelling server expeditious hearing let it wait Chalo.
That part matter. Mr. Dhor was submitting, he will possibly take another 5 minutes. My reply, another 10 minutes. That is
Only few revisional applications left.
for my lord, it will not much.
For everybody, it says not much.
My lord, kindly may I be permitted to mention item number 17, my lord. My lord,
For what?
24th is the date fixed.
No,
for today.
nothing. You have missed the bus. You have called twice.
Appeared, my lord, my lord. My lord was directed to that matter will be taken up after 2, my lord. But